Court number 18.
18.
Mentioned before, move them.
May I please, Your Lordship? Victim is site number 38, my lord, from the orders column, my lord.
38.
Second adjournment, my lord. Here in this case, my lord, state has filed an IA objecting my bail application, my lord. So record was called for, my lord, that has not been received, my lord. 38. The status at the file portion, right? They have filed an IA objecting my bail, my lord. So record was called for, but that has not been received, my lord.
State has filed, I think, this one. As per your information, record not yet received.
Not received.
Record not yet received. List accordingly when it can be listed. To submit
After vacation.
after vacation.
38.
After 2 weeks, you are little. After 2
My lord,
weeks.
after 2 weeks. Any day.
LCR,
Appeal अपने file को state है.
here my LCR call for but not received, man.
Yeah, that's what he is submitting.
Yes, ma'am.
Any day. Obvious.
May I please, Your Lordship, I beg to mention item number 52 from the supplementary list, Your Honor. The engaged counsel could not take up the matter as he has to attend the important seminar for CGC, Your Honor. Your Honor, may kindly please.
Who is the youngest counsel here?
B Deka,
B. Deca.
B Deka.
At a request made by the London Council body. Have you informed the?
Yeah, we have taken the consent, Your Honor. Your Honor, fix the matter on Monday. It's very important, Your Honor.
The consent of this and so, the council appealing on behalf of Mr. B. Deca, paid for an adjournment. List after 1 week. It will be listed after 1 week. only.
1 week or 6. Deeply obliged, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 49 and 50, my lord, hearing matter, my lord. These cases are conducted by Senior Counsel Mr. Z. Kamar, my lord.
Both 49 and 50.
49. After 2 weeks, my lord.
Then they came. 49 and 50. Paid for an adjournment, stating that the senior counsel, Mr. J. Kamar, is not available. When it can be listed? Both the matters will be listed after 2 weeks.
May I please, Your Lordship? Regarding item 25, Lordship, they have informed that charges has been filed, Lordship.
25.
Not,
Lord. No, he took it.
it is, my lord, item 25, my lord, charge sheet number 157 of the 24.
CS 1,
157 of the 24 dated 16/9/24.
CS Decoction, CS 157 24, dated 16/9/24 there. There's a format of order, we say, अपनी side होगा. It can be there. CS submit kora site. It is disposed of. We'll give you direction to appear before.
Lordship. And item 26, Lordship, they are saying
You take.
দুই বিচার লোন
কুকুরবার করে দিও আমার মধ্যে কি শাসি দেয়া নাই মানে কোড যাই পান
মানে here, my lord, in
item
20
26 lordship
Huh.
they are saying that lordship a mandatory period is over lordship it is to the 93 days lordship they are saying that Sasi has submitted lordship but they could not produce the date lordship may I pray let it come on Friday along with the copy of Sasi lordship they can get in WhatsApp also lordship 3002
at least we can give the date. Proper instruction.
26 Likho, heard Mr. S. Muni, the learned counsel for the petition, also heard Mr. MP Goswami, the learned additional PP, appearing on behalf of state respondent. Considering the submission made by the learned counsel, Mr. Munir, the additional PP is hereby asked to produce the charge sheet number along with the charge sheet if already filed. List accordingly
Yeah.
Friday.
Yes,
Friday which date? Date 29/10.
and
Okay.
one more prayer lordship one listing was there for bail hearing lordship order was there list after 2 weeks lordship now we are in 4th week lordship is not listed any date lordship convenient to court lordship it is a special act is there Any date, Lordship, convenient to both.
Yes,
Monday, Lordship,
Monday, but I cannot say Monday.
then Tuesday, if possible.
4/12. Realistic under 4/12.
Then
Wednesday.
fifth, Lordship, if possible.
Better to take 4th because 5th, there are lots of matters are there.
Lordship, Lordship. Much obliged, Your Lordship, much.
Lordship, I beg to move item number 36. Lordship, senior counsel Mr. A.K. Purkasta is on leave, Lordship.
Senior counsel, Mr.
A.K. Purkasta is on leave, Lordship.
is on leave.
It may be possible, Lordship, for today.
He was for aspirant number 2. What is the status here, dear, Gusami?
Here was it is not received, madam.
Is there any interim and all? Was there any interim? Interim was not there, no?
Not there, madam. Item 30.
Item 36 for when billing for she did not receive. Issue reminder. And also considering the submission made on behalf of NKS Council, Mr. A.K. Purkasta for respondent number 2, matter is adjourned. Is accordingly when it can be.
Madam, they did be required, madam, after a week, madam. Because left because.
9/12.
May it please your lordship, lordship, I beg to mention for listing a criminal revision petition lordship on 4th lordship. Actually, this matter cannot be taken by court 18 lordship.
No, court 18 make a mention before court 18.
This matter cannot be taken up by court 18 because lordship, the appellate order has been passed by the honorable justice. With the
Mention can be made. It mention can be made. She may not take. I mean, that court may not in a position to take up the matter, but may make a mention or make a mention before the, sorry, take consent with the registry also. Maybe listed.
obliged, your lordship.
May I plead your lordship? I beg to mention item number 51, lordship. Senior counsel Kamal Narayan Chaudhary will be appear in this case, lordship. He is out of station today, lordship. So matter may be adjourned for a date.
Item given.
51.
51.
51, lordship.
With the consent of the other side, the counsel for the petitioner appearing on behalf of Mr. K.N. Chaudhary, the senior counsel paid for an adjournment, prayer allowed. List the matter accordingly after 2 weeks, which will be 3 weeks, after 3 weeks.
May I please, your lordship? Lordship, I beg to mention item number 23. The updated case record and the status report may be called for, lordship.
No, we have received 23, you are saying?
Yes, lordship.
The scan copy is already here with us.
Case status, Lordship.
23 likho, considering the submission made by learning counsel for both sides. Updated scan copy of the record along with the present status report of the case be called for. Registry will do the needful. List accordingly. It will be delivered
Deeply obliged.
after 2 weeks, list after 2 weeks.
Deeply obliged.
Wait, please, Lord. Lord, in regard to item 45, it's an order matter. Lord, I'd like to request your lordship, it can be taken at 2 p.m. only.
Okay, we'll mark it, we'll try our best.
My lord,
But
I
no, it
understand
may,
there-
may or may not reach also, but still we'll try.
Much.
Item 1 for motion.
May I plead your lordship?
In this case, my lord, I have challenged the maintenance order, my lord.
The petitioner is directed to pay monthly maintenance of rupees 8,000 to the respondent number 2, your lordship. And the petitioner before your lordship is a labor. He's engaged for doing some repairing or daily waste labor, your lordship. And
When the order was passed?
on 27/24, 20 July,
20 July.
my lord. And in persons of the interim order, my lord.
It was an interim.
No, interim maintenance was there and the petitioner had been paying 3,000 as interim maintenance. And after passing this judgment, he cannot pay 3,000. So now he is not paying. But
Not
he's-
paying.
Presently, he cannot pay. 3,000 is not accepting by the learned court.
Hmm.
My lord, he is ready to pay 3,000 monthly, my lord.
That was so only interim was there.
My lord.
That was only interim prayer.
But,
I mean, the first party is alone or she has any children?
no children, alone. I have old aged mother, your lordship, aged about 67 years. I have to maintain my mother myself. So 8,000 is so high amount, your lordship, for its labor person. So your lordship may kindly issue notice and till pendency
You're
of,
Mr. Rahman,
I will pay 3,000.
you're Mr. Rahman,
Yes, your lord.
heard Mr. A. Rahman, the learned counsel for the petition. And also heard Mr. R.G. Burwan, the learned additional PP appearing on behalf of state respondent number 1. And this is an application under section 438, read with section 442 of BNSS against the implement judgment and order dated 20/07/2024, passed in MR case number 01 of 2022 by learned CGM Bojali Patsala, whereby the petitioner is directed to pay an amount of rupees 8,000 per month towards maintenance and issue notice on the respondent number 2 and also call for the scan copy of the LCL post. Next para. Mr. Rahman further submitted that prior as per the interim maintenance order, the petitioner was paying rupees 3,000 per month regularly, but he is not in a position to pay rupees 8,000 per month as the final awarded amount. And hence prayed for stay of the order, impugn order dated 20/07/2024 till disposal of the present petition, full stop. However, he is ready to pay rupees 3,000 per month to the petition respondent number 2 till disposal of the present application. Next para, considering the submission made by so and so, the petitioner is hereby directed to pay rupees 5,000 per month.
4,000.
5,000 per month till disposal of the present petition. List accordingly after 4 weeks.
Oblige, your lord.
Item 2.
Mayor, this email petition has been filed, my lord, for quashing of complaint case, which is pending before the additional CJM Morigaon. The fact is that, my lord, the complainant is was a student and he filed a complaint against the daughter of the petitioner, my lord, alleging that there was an agreement for marriage by the daughter of the petitioner, and while she was only student of her secondary, my lord. And the agreement was made, it is alleged that in 2017, while she was only 17 years old age. And London Trial Court has taken the cognizance by only framing the charge against the father of the girl, my lord. Girl was released from the charge. But now my prayer is that, my lord, since the agreement was made by a minor guy, alleging that she will get married with that boy, but after 6 years and 5 years, he is alleging that he was cheated and deprived. Now the girl is studying in master degree, my lord. And at this stage, he has come with a complaint before the CJM that he has been betrayed. He was betrayed by the girl. And by ignoring that part, the Landed Trial Court has taken the cognizance, my lord. So my prayer is that that is not maintainable, my lord. Because there is no ingredients for
Have you annexed the copy of the agreement?
agreement. No, my lord, it is not with me. They also did not annex, my lord. There is no copy of agreement I have taken the ground, was annexed and supplied with us, my lord. That was with the complainant, my lord.
Then how can we say that
So
the-
record may be
the-
called for, my lord. Record may be called
the
for.
girl entered into an agreement, there's nothing is here.
Yes, my lord. Agreement is
And-
not with us, my lord.
Agreement copy is with you.
No. With the complainant, my lord. Opposite party.
And where is the order of cognizance?
Order of cognizance, your lordship will find. That was not very lordship will find, that was IA has been found, my lord. It was not engaged. Later on I have submitted. IA page 9, my lord. IA is there. IA is there. That was not. Statement, not order. Page 9 of the IA, my lord. Lordship will find IA is there. Page 9, annexure 3, order dated 3/4/24. Lordship got it. Following is present peruse. Sufficient material found against the accused person, Motilal Roy, is the father. No material found against other accused, that is the girl person. And cognizance is taken under section 294/506 IPC, issue summons. So only against the father, one person, and there were cognizance was taken. So there is a totally frivolous complaint, and vexatious ground that was filed, complaint was filed in 2023, and 24 technicians was taken. And allegedly agreement was made in 2017. So my prayer is that you may issue notice. Call for
It's
the
a
record-
complaint case.
Complaint.
Now your application is, if father is
Father is how?
not
father-
the signatory of so and so,
No,
then
father is not signature, madam. That called for. It is a question of. There is nothing mentioned the father made, and also you will find the deposition of the complainant. I have arranged the deposition. Lordship will get page 20. Deposition of witnesses, page 20 of my petition. And page 18 is the complainant's deposition. And it's 2 of my. Annexure 2. Where he stated that Nirupama Rai since long on 4/10/17 we have signed a marriage agreement. Only daughter. Before notary public in the court, but I told her further to solemnize social marriage. She delayed the matter. Thereafter, he also informed me that he had got a better groom. So this is the ground.
okay. Yes, you are formal, I think.
Yeah, my lord, I'll have it on the basis of which complaint is taken, my lord. There is page number 19, my lord. The deposition of the complainant, my lord.
No, this is the Barnacle, yes.
Yes.
Complainant, my lord. I am only reading my 2-3 line, my lord. মই নিৰুপমা ৰৈক বহু দিনৰ পৰা ভাল পাইছিলো। 4/10/17 তাৰিখে মই তাইক আদালতত আহি নটাৰীৰ যোগেৰে এগ্ৰিমেণ্ট বিয়া পাতিছিলো। কিন্তু মই তাইৰ দেউতাকক আমাৰ মাজত সামাজিকভাৱে বিয়া পাতি দিবলৈ কোৱাত তেওঁ আমাক বিয়া পাতি দিম দিম বুলি পিছুৱাই থাকে পিছত মোক কয় যে মোতকৈ ভাল ল'ৰা এজন পাইছে আৰু সেই ল'ৰাৰ লগত নিৰুপমাক বিয়া দিব sitting and my lord just
So, my lord, whether this is a buried in the eye of law regarding Hindu marriage.
notice this
Agreement is not a matter of marriage under the Hindu law.
Mr. Sarkar.
It's not.
Heard Mr. Esnas, the learned counsel for the petitioner. And also heard Mr. Ajay Purva, the learned additional PPA paying on behalf of status fund number 1. Bakihin likhibo. This is an application 42528 issue notice. To the respond number 2 to register ADN as usual process. No formal notice is required to be served on so and so. Call for the scan copy of DLC.
Lordship, in the meantime, Lordship, I have a prayer that further proceeding may be stopped, my lord. Because the my lord complainant petitioner is a very school teacher, my lord. School teacher.
Considering the submission made by the learned counsel for the petitioner, let the further proceeding in CR case number 98 of 2023 pending before CGM Morigaon. Additional CGM Morigaon be state till next date of listing. List accordingly. One is the I stand for? I is for?
I am for submitting, sir, I am a remain, my lord, because there is a document submitted.
I am they have not annexed my lord cognized this order taking.
That's why I have submitted it.
So I am my lord they have brought this my lord order.
That will not record me. That may remain.
It will be like a
Remain. Obligation.
list after 4 weeks.
Item 3.
Yes.
May please the lordship. That we have filed this petition, my lord, for quashing of FIR and as well as proceeding of the case, my lord. FIR, my lord, page 16. FIR filed on 23rd of November, my lord, 2022. The informant, my lord, aged about 23 years. And her first line, my lord, may read, my lord. The humble submission is that I have love affairs with the accused number 1 since last 2 years. The accused person is working as an army personnel and staying in Delhi, and he used to talk with me over phone from Delhi. While the accused number 1 came on leave, he brought me to different places by promising to marry me, and he used to develop his physical relation with me against my will. In this way, on last week, the accused number 1 came home on leave and met me at so-and-so college and proposed me. On 21/12/11/2022, while I was on the way to college, the accused number 1 called me over phone and asked me to meet him at so-and-so. On the request of the accused, I met him at so-and-so at about so-and-so. Thereafter, the accused number 1 and 3 brought me to a dhaba at Shorbuk by four-wheeler vehicle and committed physical relation with me against my will by promising to marry me. The accused number 1 also gave his ATM card to me for convince me. Then I was brought to another dhaba and there also he has committed physical relation. After leaving dhaba, the accused number 1 refused to marry and then secured my signature and forced the accused number 1. Then the accused number 1 called the accused number 2 over phone, and the accused person mentioned in the affair assaulted me and fled away. On the basis of this FIR, my lord, case has been registered. And during investigation, my lord, he approved this all court for my lord bail. The honorable court, my lord, finding the allegation, my lord, to be some absurd, my lord, was pleased to grant him bail. case my lord 25. Now, my lord, police, my lord, without my lord recording any my lord materials in the regarding investigation, one case charge sheet has been submitted, case 35. The basis of charge sheet, my lord, the Planet Trial Court has taken cognizance on my lord 30th of August, my lord, case 39. And someone has been issued. So, prima facie, your lordship considered the FIR, my lord. The ingredients of the offense, my lord, completely missing, my lord. And in this point, my lord, the Honorable Supreme Court, my lord, very recent judgment, my lord. In this case also, they, my lord, maintained relationship for 2 years. And when the marriage failed, my lord, filed FIR. The Honorable High Court, my lord, rejected the petition for quashing. The Honorable Supreme Court allowed, my lord. Paragraph 18 may kindly be seen, my lord. Exactly similar. They are also, my lord, they were in relationship for 2 years. 2004, my lord, Supreme 1069. Decided on 20th of November 2024. But this notice may issue, my lord, according to call for. Proceeding may kindly restate. No, it's a such that case, my lord. Lordship may kindly come to page number 37, my lord. But I am reading, my lord, the fifth line, my lord. Of page number 37. পদকীয়াজনে ঘৰলৈ ছুটিত আহিলে ওচৰীয়ানীক বিয়াৰ প্ৰস্তাৱ দি বিভিন্ন ঠাইত ফুৰাবলৈ নি দৈহিক সম্পৰ্ক কৰে। এনেকে চলি থকাৰ এসপ্তাহমান আগতে পদকীয়াজনে চাকৰিৰ পৰা ছুটিত আহি তেওঁ পঢ়ি থকা BHB কলেজত সৰুপেটাত লগ কৰি প্ৰেমৰ প্ৰস্তাৱ দিয়ে। My lord, entire incident, my lord, my lord, because he was given false promise to marry, my lord. So false promise to marry, my lord, if somebody, my lord, indulges in, my lord, physical relationship, my lord, that will amount to 376, my lord. So, my lord, Sashid has been submitted, my lord, so that the notice be issued, my lord. And regarding stay, my lord, I have objection. My lord.
The problem is that once the matter is stayed, it will be stayed for 2, 3, 4, 5 days for long. That is the main issue. Otherwise,
Let the opposite party examine, my lord, after that, my lord, this honorable court finds that, my lord, there is sufficient materials to match. So, my lord, those may pass necessary order. But at this stage, my lord, I am opposed.
Similar option, my lord, in paragraph 18, my lord, the Honorable Supreme Court, my lord, discuss, my lord. She is a, my lord, educated lady. She knows everything. And she is
that will
consent.
come later on at the time
She
of
is
final
consenting.
order.
Without her consent, my lord, this thing not happened, my lord. Exactly similar situation in the earlier case, my lord, I have relied.
Heard Mr. R. Ali, the learned counsel for the petitioner, and also heard Mr. R.G. Borba, the learned additional PP, appearing on behalf of state respondent. It's an application under section 528 of the MSS for quashing of the entire proceeding in session case number 36 of 2024 under section 417, 376, 406 IPC, pending before the learned district and session judge Bojali Patshala, and also prayed for quashing of the impugn, also prayed for the quashing of the first information report, FIR, FIR, as well as the CS number 235 of 2023, dated 30/06/2023, submitted against the present petitioner under section 417-406-376 IPC in connection with Patachar Kusi case number 1201 of 2023. Issue notice on the respondent number 2. No formal notice is required to be served on respondent number 1. However, extra requisite copy may be served during the course of the day. Mr. Ali further submitted that with some false and concocted allegations, the FIR has been lodged against the present petitioner. And both the accused petitioner and the victim respondent had love affairs, but only with the allegation that he refused to marry her, the FIR has been lost. In this context, Mr. Ali also relied on a decision of the Honorable Apex Court. Honorable Apex Court reported by 2024 0S Supreme SC 1069. Prashant 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 versus State of NCT of Delhi. Wherein also in a similar situation, the Honorable Apex Court
There were 18 and 19.
and also post the proceeding with a view that the relationship between the parties were consensual relationship, and the allegation cannot fulfill the ingredients of section 376/417 IPC. Next paragraph, considering the submission made by the learned counsel for the petitioner, the further proceeding in connection with session case number 36 2024 be stayed till next date of listing. On appearance of the petitioner other respondent, the matter will be finally heard and decided. List accordingly after 4 weeks.
Item 4.
Your Lordships,
Not to my senior medical BC9 is like other course, matter may pass over time limit. Okay.
Item 5.
Meet Vijay Rosh. This is this application for quashing a criminal proceeding. The petitioner before Roship, my lord, he is a very renowned surgeon. He was a former professor and head of the Department of Surgery in Guwahati Medical College. Your Lordship, the FIR was lodged. Your Lordship will find that at page 22. One patient, my lord, died after operation, after surgery. Page 22, your Lordship will find the, my lord, typed copy of the FIR. May I read it, my lord? To the officer in charge, Bhangar Police Station. With due respect, I am the wife of Manjit Das. My husband was admitted at Namcare Hospital, Bhangar. As per doctor's advice, my husband did gallbladder operation on 7/1/2020 with full assurance of recovery. Dr. Manoj Kumar Chaudhary. Unfortunately, it was declared on 10 January 2020 time around 5:15 p.m. Staff of doctors, Namcare Hospital, about death of my husband. Therefore, it is raised serious doubt of my death of my husband, that his death was happened due to serious negligence of doctor on duty. It is therefore pleaded So this is the my lord allegation. On that basis, my lord, the case was registered under 304A and 34. And eventually, my lord, police gave a my lord charge sheet. Now, my lord, I'd like to draw your lordship attention to the my lord report of the medical board that your lordship finds at page 27. Report of the medical board of Guwahati Medical College. Page 27, it starts. Office of the Department of Surgery, GMC. Now, my lord, this subject medical report in terms of Bhavnagar PS case number such and such. My lord, there were reports submitted by Dr. M.K. Chaudhary, Dr. T. Raswa, Dr. Pranab Kolika, Dr. Kishore Burman, and then your lordship may kindly come to the conclusion at page 31. This is the conclusion of the medical, my lord, the medical board. Page 31, paragraph 8. Has your lordship got it? Huh? Treatment details are available in the records provided, and different symptomatic treatment measures were taken in the post-operative period. From this treatment point of view, this board do not get any evidence of negligence in treating the patient in the ICU. So, my lord, the medical board has clearly stated that, my lord, there is no negligence. So, in spite of that, my lord, the charge sheet, if your lordship finds at page 32A, because, my lord, the report of the charge sheet is, my lord, the charge sheet is on the basis of the report and also on the, my lord, forensic report, when, my lord, it was said that toxicology, my lord, no poison. But in spite of that, in a very, my lord, cryptic manner, page 32A, your lordship will find. Page 32A, last one, name and address of the witnesses, then next page, my lord. Sorry. Second paragraph, during the investigation, the place of occurrence was inspected. The statement of the informant and the witnesses were recorded. Inquest of Monjit Das was done, and PM report was collected. During investigation, medical board was constituted, and the report of the medical board was obtained. On examination of the aspect, of all the aspects during the examination, it was found that the said case was under section 304A IPC is found well established. In spite of that report, my lord. Now, your lordship is aware of the, my lord, the decisions of the Honorable Supreme Court regarding the, my lord, harassment that has been meted by the, my lord, the unhappy, my lord, family members of the deceased. If I may, my lord, kindly draw your lordship attention. Jacob Matthews case, your lordship is aware, my lord. If your lordship permits, I'll read only one paragraph from that, my lord. Because in Jacob Matthew, the Honorable Supreme Court has said that there has to be some statutory guidelines protecting the doctors. And till that time, some guidelines were, my lord, laid down that your lordship will find, my lord, that the last page, paragraph 52. In fact, my lord, paragraph 50 and 51 is also important, but I'll read only paragraph 52. Statutory rules or executive instructions incorporating certain guidelines need to be framed and issued by the Government of India and or the state governments in consultation with the Medical Council of India. So long as it is not done, we propose to lay down certain guidelines for the future, which should govern the prosecution of doctors for offences which criminal rashness or criminal negligence is an ingredient. A private complaint may not be entertained unless the complainant has produced prima facie evidence before the court in the form of a credible opinion given by another competent doctor to support the charge of rashness or negligence on the part of the accused doctor. The investigating officer should, before proceeding against the doctor accused of rash and negligent act or omission, obtain an independent and competent medical opinion, preferably from a doctor in the government service, qualified in that branch of medical practice, who can normally be expected to give an impartial and unbiased opinion applying the Bolam test to the facts of the facts collected in the investigation. Now, your lordship has already seen, my lord, the medical board has given an opinion in favor of the my lord, petitioner, in spite of that, my lord, the charge sheet has been filed and my lord, the Honorable Trial Court has taken cognizance, my lord. Another decision, if your lordship permits, my lord, ASV Narayana Rao 2013-10 SCC. There are many cases, my lord. I'll not trouble your lordship, but this your lordship will kindly read paragraph. In paragraph 9, my lord, the Jacob Matthews, my lord, guidelines have been quoted that I'll not read again, my lord. Your lordship may kindly read paragraph 11. Last page. Paragraph 11, may I read it, madam? From the final report submitted by the police in the instant case, it can be gathered that the records pertaining to the treatment given to the deceased were forwarded to Andhra Pradesh Medical Council and also the Medical Council of India, which opined that the doctors seem to have made an attempt to their best as per records. However, the High Court thought it fit to continue prosecution of the appellant. So, my lord, the High Court, my lord, did not quash it, but the Honorable Supreme Court has quashed it, my lord. Here also exactly similar, my lord. The report has been given by the medical board that there is no negligence. It's a very rare case, in fact. In a very rare case in the medical report, if your lordship reads, my lord, in 1% of such cases all over the world, after the operation, this type of complication arises. That has been recorded in the medical report, my lord. Therefore, my prayer, your lordship, is that your lordship will issue notice and my lord stay the further proceedings of the. If there's my lord, notice may be issued, my lord. Secondly, my lord, the search is submitted, my lord, under two sections, my lord, 304A and 34, my lord.
Who is 34? Another person? Who is
34,
another?
my lord. There is
Another person is?
no, my lord, only the petition. Initially, it was registered under 304A and my lord 34, but the charge sheet has been filed only in respect to the petition.
My lord, I have seen the search sheet also, page number 32, my lord, 32D. 32D is the, my lord, vernacular page, my lord, search sheet, my lord. Only this person has been, my lord, shown as an accused, my lord. LCM may be called from, my lord, to be recorded.
By Mr. M.K. Chaudhary, Lilani, senior advocate, assisted by
Mr. T. N. Srinivasan.
Mr. P.N. Srinivasan.
T. N. Srinivasan.
T.N. Srinivasan, likha আছে total নাম. So and so, and also heard Mr. R.J. Borua, Lilani additional PP, appearing on behalf of state respondent. তাৰপিছত বাকীখিনি লিখিব. This is an application on section 4. This is under
It was
482.
filed under 482. Then, my lord, on the last occasion, we made a mention that, my lord, in view of the, my lord, division bench decision, division judgment also, my lord, came on 11. Thereafter, my lord, it has to be corrected, but we approached the authority, my lord, registry. They said that unless there is an order, we cannot correct it. But then, my lord, the notification, your lordship must have seen, my lord, the division bench judgment and the notification. It says, my lord, it can be corrected. My lord, the division bench judgment.
No, it's okay, then we'll you just modified cost title you can give.
Yes, ma'am.
Otherwise, it's okay. We pass the order, next date of listing, you will just file the modified orders.
Right.
This is an application on section 482 CRPC for quashing of the FIR in connection with Bhangagar PS case number 17 of 2022, 2020, and all proceedings based thereon. Full stop. The also prayed for quashing of the order dated 6/12/2023 passed by learned SDGM Kamrup M in PRC case number 2674 of 2023, whereby the cognizance has been taken against the present accused petitioner under section 304A IPC. Full stop. Issue notice on the respondent number 2.
2.
Yes, no formal notice is required to be served on respondent number 1. However, extra requisite copy may be served during the course of the day. Heard on the next para, heard on the interim prayer poster. Mr. Chaudhary, the learned senior counsel, submitted in this regard that the present petitioner is a very renowned surgeon, and surgeon and with some false allegation, the FIR has been lodged against him, alleging that there was any negligence on part of the petitioner while doing the operation of the husband of the present informant. He further submitted that during the investigation, the IO also obtained a medical report of the report from the medical board constituted. Who was there? Do you remember?
My lord, that
Medical
was
board is at 27. Na?
page 27.
Was the where the Dr. M.K. Chaudhary, comma, Dr. T. Rajkwa,
No,
comma.
in fact, my lord, MK should not be there. He is the, my lord, the accused.
Oh, yes, yes.
Your lordship will find, my lord, 3 persons at page 31.
Sorry, sir. 31. Constituted by
Dr. P.K. Das, Dr. Purujit Chaudhary,
Dr. P.K. Das.
my lord. Member Secretary, then my lord,
Dr. P.K. Das.
then
And
my-
another Dr. P.P. Das is also there.
Yes, my lord. Then Dr. Purujit Chaudhary, he is the professor, head of the Department of
And
Surgery.
Dr. Purujit Chaudhary, wherein it is clearly mentioned that there was no evidence of negligence in treating the patient in ICU. In spite of the said report, the IO has submitted the charge sheet and the learned trial court below also took cognizance accordingly. Mr. Chaudhary, relying on the decision of Jacob Matthew, JACOB MATHU, Jacob Matthew, and also relying on another decision of the Honorable Apex Court reported in 2013, 10 SCC 47741, has submitted that and the Honorable Apex Court gave a clear guideline for obtaining proper medical opinion of the medical board opinion before taking any cognizance or filing any charge sheet against any doctor. But in spite of the report obtained by the investigating officer, the case has been charge sheeted against the present petitioner. Accordingly, he paid for stay of the proceeding till next step, till the disposal of so and so. Till the disposal of the present petition, full stop. Considering the submission made by the learned counsel for the petitioner and other aspects of the case, let the proceeding be stayed till next date of listing. Further, the petitioner is also hereby directed to file an amended cost title of the amended cost title by inserting the proper provision of law in the present petition. List accordingly. After 4 weeks, it will be listed. In the meantime, you file the amended.
Highly obliged.
Oh, sorry. Scan copy of the LCB call for.
Okay.
Item 6.
Yeah, please. Yes. As directed by this honorable court, copy was served to the standing council of. Issue. Next is. Perhaps your name
Yeah.
is not shown in the.
Name
report,
not
cause
shown,
list.
my lord.
That is why.
Whether you inform or delegate.
Because of.
Heard Mr. E. Ahmed. Heard Mr. E. Ahmed, the learned counsel for the petitioner. It is submitted by him that in pursuant to order dated 2011-2024, he already served the copy of the petition to the Standing Council Income Tax Department. Full stop. However, it is seen that registry has failed to reflect officers failed to reflect the name of the Standing Council Income Tax Department. Accordingly, the registry is hereby directed to reflect the name of so and so on the next set of listing without fail. After 1 week can be listed. এটি বিষয়টাকে কি করলো মানে 9/12 we are listing it. 9/12.
10 will be convenient for
10. Okay.
May I
Yes.
please, Your Worship, this is an application by which method I'm praying for the quashing of the impugned FIR as well as the search sheet submitted by the police method.
Hmm.
First of all, method, I like to draw your attention, method, in page 20, this is the FIR
22.
20.
Acha.
And the vernacular is at page 23. Maybe taken up vernacular, it is very clear. সম্মানপূর্বক বিনীত নিবেদন এই যে উপরোক্ত আসামিজনে তার কোনো ধরনের অনুজ্ঞাপত্র নোহোৱাকৈ বহুদিন ধৰি সুদৰ ব্যৱসায় চলাই আহিছে যোৱা 20/7/2022 তাৰিখত মোৰ বিশেষ প্ৰয়োজনত উপৰোক্ত আসামী আছাদুৰ ৰহমান পিতা মৃত্যু মতিউৰ ৰহমান গাঁও কাকুৰপাৰা চৰঞ্চ 10 লাখ টকা ঋণ খোজো তেখেতে মোক কিছুমান চৰ্ত দিয়ে মাটিৰ ৰেজিষ্টাৰ দলি মাটিৰ কম্পিউটাৰ কপি চিটা কপি ল্যান্ড হোল্ডিং কপি নাম্বাৰস অফ বেংক চেক ইউকো বেংক চৰঞ্চ দলিল মোৰ আৰু মোৰ পত্নী মামনি বেগমৰ সহি লয় সহি নিদিলে ঋণৰ টকা নিদিয়ে আৰু কয় যে এইবিলাক দিয়ে আমি একো নকৰো পইচা উভতাই দিলে ডকুমেন্ট বিলাক উভতাই পাব মাটিৰ বিৱৰণ মানকাছৰ টাউন বন্দিত গাঁৱত 196 নম্বৰ মেধিপাট্টাত 545 চৰঞ্চ দাগৰ এটকঠা মাটিৰ হাৰুণৰ ৰচিদৰ নামত থকা ড্ৰাফট চিটা ৰেকৰ্ড আৰু উপৰোক্ত ডকুমেন্ট বিলাক জমা লয় আৰু 10 লাখ টকা 10% সুদৰ হাৰ হিচাপে ঋণ দিয়ে উক্ত ঋণৰ সুদ দি থকা অৱস্থাত আকৌ যোৱা এটা তাৰিখত আৰু এটা তাৰিখত 3,50,000 আৰু 5% সুদৰ হাৰ হিচাপে ঋণ লয় উক্ত ঋণৰ পৰা বিভিন্ন সময়ত তেখেতে 13 লাখ টকা উভতাই দিওঁ আৰু তেখেতৰ ঋণৰ পৰা মই আৰু মোৰ পৰিয়ালৰ লোকে বচাৰ কাৰণে যোৱা ইংৰাজী 1 তাৰিখত 1 বিঘা মাটি পট্টা যাৰ মূল্য 1 টকা তেখেতক ৰেজিষ্টাৰ যোগে বুজাই দিওঁ আৰু মই জমা দিয়া সকলো ডকুমেন্ট বিলাক উভতাই বিচাৰ তেওঁ কয় যে উক্ত 1 বিঘা মাটি ৰেজিষ্টাৰ কপি হাতত পোৱাৰ পিছত মাটিখিনি বুজাই লৈ আপোনাৰ ডকুমেন্ট বিলাক উভতাই দিম আৰু উক্ত লেনদেনৰ হিচাপ নিকাচ কৰাত মই তেওঁৰ পৰা 10 লাখ টকা পাবলগীয়া হওঁ কিন্তু আসামীজনে উক্ত ঋণ দিয়া টকাৰ সুদৰ হাৰ নিজে অবৈধভাৱে বঢ়াই 20% সুদ লগাই হিচাপ কৰি আৰু পইচা পাব বুলি কয় আৰু মোৰ ডকুমেন্ট বিলাক ঘূৰাই নিদিয়ে আৰু যোৱা ইংৰাজী 1 তাৰিখে মোৰ নামত নোটিশ পঠায় তেখেতক জমা দিয়া মই আৰু মোৰ ঘৈণীয়েক সহি কৰা ব্লেংক দলিত জলিয়াতি কৰি এগ্ৰিমেন্ট বনাই মানি ৰিচিপ্ট বনাই সেল ডিড বনাই আৰু মোৰ নামত নন এফআইআর সিভিল কেস দায়েৰ কৰে আৰু তেখেতে মোৰ নামত বেংক চেক বনাস বাউন্স হোৱাৰ কেস দায়েৰ কৰিব বুলি ভাবুকি প্ৰদান কৰি হাৰাশাস্তি কৰি আছে আৰু আসামীজনে চফা অস্ত্ৰ আদি লৈ মোৰ ঘৰত আহি মোৰ পৰিয়ালৰ মানুহক ভয় ভাবুকি প্ৰদান কৰে আৰু কয় যে ঘৰত তলা লগাই দি সকলোকে ঘৰৰ উলিয়াই দিম আৰু প্ৰাণে মৰা ভাবুকি দি থাকে আৰু কয় যে আমাৰ এই জিলাত মোৰ ওপৰত কোনো একো কৰিব নোৱাৰে তুমি জানানে মই কাকৰিপাৰা এলেকাৰ কিমান মানুহৰ মাটি বাৰী দখল কৰিছে আৰু আসামীজনে এই অঞ্চলত বিভিন্ন দুখীয়া মানুহৰ এটিএম কাৰ্ড বেংক একাউণ্ট আৰু মাটিৰ দলিলসমূহ লৈ গৃহহৰা কৰি দিয়ে তাৰ প্ৰমাণ বহুতো আছে আৰু মানুহক 1% সুদৰ হাৰত অবৈধ জোৰপূৰ্বক টকা আদায় কৰি হাৰাশাস্তি কৰি থাকে আৰু টকা আদায় কৰাৰ নামত হাট বজাৰত বহুতো দুখীয়া মানুহক হাৰাশাস্তি আৰু মাৰপিট কৰি থাকে আৰু বহুতো নিৰীহ মানুহৰ জীৱনলৈ ভাবুকি কঢ়িয়াই আনিছে পদক্ষেপত পৰিকল্পিত হৈ এনে আইন অমান্য কামত নিয়োজিত হৈ ধনপূৰ্ণ সহযোগৰ ব্যৱস্থা কৰি আছে গতিকে মহোদয়ৰ ওচৰত অনুৰোধ জনাওঁ যে তেখেতে উক্ত বিষয়ে তদন্ত কৰি মোৰ ডকুমেন্ট আৰু মই তেখেতৰ ওলাই টকাখিনি আসামীজনৰ পৰা উভতাই দিয়াৰ ব্যৱস্থা কৰে দিম After lodging this FIR, the petitioner was arrested on the same day, that is of 19/2/2024, and he was forwarded to the jail hazard. And accordingly, on 27/2/2024, he was released on bail. Only just after 8 days from the filing of the FIR, the police has filed the charge sheet. Now, my lord, the actual fact of the case that I will show before your lordship from his own statement, made an oath before the court, that this FIR has been filed completely on false and fabricated plot design by the petitioner only to defraud and cheated the amount which is taken from the petitioner in the name of selling of his land. That is the actual fact. Well, can you see now the informant was approached to the petitioner for selling of his land, and by which the land was finalized at the amount of rupees 30 lakhs. And on 25/7/2022, well, can we turn page 35? This is the Bainapatro made in between the informant and the petitioner. The purchaser Ashadur Rahman, that is the petitioner, so and so, and seller is Harunur Rashid, son of late so and so, that is the respondent number 2, that is the informant hearing. Whereas the purchaser proposed to purchase my own possessed bureau schedule plot of land measuring so and so, by way of absolute sale at the total consideration of an amount of rupees 30 lakhs only, and on being accepted the said proposal today in presence of the below mentioned witnesses, the purchaser has given a check of an amount of rupees 5 lakhs only bearing check number so and so on 25/7/2022 of UCO Kakribara. And after receiving the aforesaid amount, I have handed over the copy of the original registered deed of the land bearing deed number so and so, landholding certificate, and the computer sheet. The purchaser will pay the remaining balance amount of rupees 25 lakhs only on or before 10/1/2023. Immediately after receiving the said balance amount, I will bound to register my aforesaid land in the name of the purchaser. Otherwise, I will be liable under the law within the aforesaid period of time. The purchaser will obtain the NOC from the competent authority. I hereby sign the Bainapatro with good health, free mind, and good conscience, written by the so and so. And then thereafter, and this is the all the amount has been given by way of check. The first check was given on 25/7. This one I annex here. And thereafter, he continuously given the check to the petitioner, subsequently, on receipt of the 25 lakhs amount from the petitioner, the informant has signed the money receipt, which is at page 39. This is the money receipt signed by the informant, is the respondent number 2. Then Haruna Roshi so and so through agreement Bainapatro 25/7/22 has received an amount of rupees 5 lakhs, only check bearing number so and so, and thereafter, as per the said agreement so and so, I have rupees 5 lakhs only by check bearing number so and so, and rupees again 5 lakhs by bearing check number so and so, rupees 5 lakhs so and bearing check number so and so dated 24/11. In total, he had received 25 lakhs from the petitioner out of the total consideration of the amount of 30 lakhs. The check, I have already annexed all the checks. And from the bank statement of the petitioner, it has clearly revealed that all the amount has been realized to the account of the informant. That is at page 44. I have annexed the bank statement of the petitioner. Then what had happened after given the amount of 25 lakhs, while the petitioner asked the informant to proceed for the registration of the said land, then he delayed the matter in several grounds. And having regard to that, the petitioner filed a pleader notice at page 47. This is the pleader notice sent by the petitioner to the informant for execution of the Bainapatro. He has given them. But despite receipt of this pleader notice, when no response has come out, then the petitioner, having no other option, he has filed a title suit before the Learned Court of Civil Justice Senior Division, Chalmara, which is at page 49. And the same was registered as title suit number 1/2024. So page 49 is the title suit filed by the petitioners for a specific performance of the agreement, which is made on 25/7/2022 22. On being received the notice of this title shoot, my lord, this FIR has been lost. Not prior to that. This FIR lost on 19/2/2024 and the title shoot filed on 16/12/2023. When he received the notice of the title shoot, then he taken the advantage, my lord, your lordship knows, in all over Assam. The random FIR has been lost in some the brokers and some other persons like as alleged in the FIR, my lord. By taking that advantage and on receipt of the title shoot notice, the informant has lodged this FIR on 19/2/2024. But most interesting part is that the petitioner submitted his written statement. Kindly see page 59. And the statement made in the written statement does not tally with the FIR. He clearly admitted all the amount which is given by check by the petitioner. But in the FIR, he has stated in different mode of accepting the amount. And the amount which is stated in the FIR does not tally with the written statement made by the respondent number 2, my lord. Well, kindly peruse the relevant portion, page 61, my lord. Para 12 of the written statement submitted by the informant. That as regard the statement of the para number 4 of the plain, your lordship got it. Para number 4 of the plain, it is admitted that the loan amount, here he said the loan amount of rupees 20 lakhs was received by the defendant by check number so and so, which the petitioner already annexed this check, that's the check number. The rest of the contents of the para 4 are denied. No money receipt was executed by the defendant on 8/12/2022, admitting receipt of the rupees 25 lakhs. That is admitted. And nowhere he stated as alleged in the FIR that he has taken the loan at the rate of 10% interest. Subsequently, it was increased to 20%. He returned back the 13 lakhs of the amount. Nothing has been stated in the written statement, my lord. He clearly admitted. But another thing, my lord, kindly see the order of the title shoot, page 71, my lord, wherein the counsel of the informant submitted before the learned court below that they are ready to compromise with the matter. Well, kindly see page 71. Both parties are represented. None of the parties personally appeared before this court for amicable settlement of the matter through ADR. Learned counsel for the defendant, that means the informant, has submitted that his party is ready for amicable settlement if the plaintiff side comes forward for compromise or amicable settlement. If the allegation which labeled in the FIR, had it been done by the petitioner, my lord, whether such type of submission has to be made by the counsel of the informant, my lord. If we go through the written statement of the informant and the FIR, my lord, your lordship will hide.
Okay then. Yes,
Yes.
Here, my lord, the money that has been taken, it is not in dispute, my lord. But for what purpose? In the FIR, he disputed that money which my petitioner claims that he has given for the sale of land, that has been disputed. And he has said that money he has taken as loan from him. That is why he has given him. And thereafter, since he has also given one land in lieu of that, but thereafter, my lord, showing some interest, my lord, that more money is due to him, he has filed this case, my lord. That is what the allegation is, my lord. Now, why the money has been given in the, and also in the, I think the written statement that has been pointed out, my lord. Here also he stated that as a loan I have received. So there is no denial of the receipt of the payment, my lord. Only, and thereafter the search sheet has been laid down, my lord.
That part, my lord, since this
Search sheet says, my lord, that the prima facie case has been made out against because taking the amount as loan, my lord. They have a search sheet filed. Like it was noticed, maybe it will. And the record may be there thereafter, your lordship will.
Others part, my lord, since the
Whether, my lord.
civil suit is going on, so entire matter will be decided there. And the charge sheet, my lord, filed only after 8 days from the date of lodging of the FIR.
Yes, very quick.
Yes, ma'am.
We are on 7.
Yes.
Heard Mr. R. Islam, the learned counsel for the petition, and also heard Mr. M.P. Goswami, the learned additional PP, appearing on behalf of said respondent. This is an application as section 520 is eventually given. Issue notice to the respondent number 2. No formal notice is required to serve on respondent number 1. However, extra requisite copy may be served during the course of meeting. Mr. Mr. Islam, the learned counsel for the petitioner, submitted in this regard that with some false and concocted allegation, the present FIR has been lost, where the charge sheet is also filed within 8 days from the filing of the FIR, and the petitioner, though arrested in connection with this case, he got bail immediately after. How many days later he got bail?
My lord, he was arrested on 19/2/2024, released on 27, 8 days.
After 8 days of the so and so filing, or after 8 days of her arrest. Stop. Mr. Islam further submitted that there was an agreement between the parties for sale of a plot of land by the respondent number 2, and in pursuant to that agreement, he also paid several checks, and the consideration amount of rupees 25 lakhs were accordingly paid to various checks. But after receipt of the checks, after the receipt of the money, sorry, when the petitioner, when the respondent refused to sell the land, he also filed a title suit for specific performance of contract. Wherein, full stop, where the respondent also did not dispute in regards to issuance of check and receipt of money while filing his WS in the said title suit. Mr. Islam further submitted that this was a civil suit is still pending between the parties, and only after receipt of the notice in civil suit, he lodged the complaint against the present petitioner. So accordingly, he prayed for stay of the further proceeding of the case till the disposal of the present petition. Next, but considering the submission made by the learned counsel for the petitioner, let the proceeding of pending against. He is this only accused?
For appearance, my lord, page 70.
No, he is the only accused.
Only.
Is the state to case to number asylum till next date of listing. List accordingly after 4 weeks.
Master.
My submission may be recorded.
Yes.
As a maid?
May it please, your lordship. My lord, matter relates to my lord crossing of affair and my lord charge sheet matter. There are certain land dispute between the parties, my lord, and a title suit, my lord, is pending before the my lord civil court, my lord, Koliabar, my lord. On the basis of the my lord civil transaction, my lord, the cross affair has been lodged by both the parties, my lord. First affair, my lord, in page number 2, my lord, or 17, my lord. So first affair, my lord, lodged by the my lord petitioner number 3, my lord. And my lord, second affair, my lord, lodged by the my lord respondent number 2, my lord. The second affair is under challenge by this my lord, petitioner.
You're saying first FIR is lost by?
Petitioner number 3, my lord.
And second FIR, but
Second FIR lost by the respondent number 2, my lord.
where is the first FIR?
First FIR is page number 17, my lord.
This is the first FIR.
Particular, my lord, is page number 21. First FIR allegation is that, my lord, they have entered, my lord, in the petitioner number 3's land, my lord, and my lord, the some, my lord, assaulted by the, my lord, respondent and their family, my lord. And sustained injury, my lord, and with page number, my lord, kindly see page number. Page number 22 in the picture, my lord. The petition number 3, my lord, sustained injury. And my lord, to save from the, my lord, offense of first affair, my lord, this second affair has been lodged by the, my lord, respondent number 2, my lord. Second affair is page number 23, my lord.
Not second FIR, it is a cross FIR.
Cross affair. And this is, my lord, let the notice may go, my lord.
Yes, Hussam.
And LCR call for.
Otherwise, it is a charge sheeted case? No, not yet charge sheeted.
Charge sheeted.
Charge sheet. Can copy of the LCR to call for it. I'll notice good. And the hard for it. This is an application. Yet I say vacation. Write it down. Hard Mr. Gusami for it and issue notice to the respondent. No formal notice is required for one. And also call for the scan copy of the LCR. List accordingly after 4 weeks.
Okay. Obligement.
Item 9.
Please, Lord.
Yes.
In this case, we have filed this petition for cancellation of bail. So, my lord, notice may issue.
For cancellation of bail.
Okay. FIR is 11.
You are the informant.
Lord. The father of the deceased man, victim man.
Father of the deceased.
Lord.
They got acquitted.
No, my lord.
Oh, sorry, bail was.
Bail was granted by learned sessions as well.
Acha. Heard Mr. Arali, the learned counsel for the petitioner. I also heard Mr. D.P. Goswami, the learned relation PP answer.
Yeah.
This is an application under section 528, 483, 3, subsection 3 of the BNSS for cancellation of anticipatory bail, which was granted
Accused number
to the respondents, all respondents, or
Lordship, 2 to 9, my lord. One is state, my lord.
granted to the respondent number 229. Issue notice to the respondents. Charge sheeted one.
No, not
yet.
charge sheeted.
Not.
So CD may be.
Case may be called for.
CD may be called for. Issue notice করবো, CD be called for. As notice will go, it will take some time. So CD when can be fixed?
It is
1712
1712. I don't think it will come. 1712 finally.
from Borpeta.
From Borpeta,
Barpeta. Okay then, 1712. 1712 will be.
step by using process, madam.
Steps, usual process.
Okay.
Item 10.
May I please, your lordship?
Yes.
This is a quashing petition, lordship, or quashing of NBWA, lordship. The NIA Act proceeding was going on, lordship. On lordship, 9/7/2024, lordship, page number 41. A petition was filed by the council of the petitioner, lordship, saying that he is out of station, lordship, and that for that reason he could not appear, lordship. On that day itself, NBWA was issued, lordship. Subsequently, fresh was again issued. Lordship, may kindly see page number 41.
This is an
Quashing of
petition.
quashing petition for
No. This petition was filed for,
for a date, lordship. for
it was fixed for DW.
DW, lordship. Petitioner appearing all along, lordship. But since he was out of station, could not appear some few days, that is why, lordship. At this stage, we are praying, lordship, the petitioner will be allowed to appear before the trial court,
Where
lordship.
is the impugned order?
Impugned order, lordship, page number 44, lordship. On that day itself, NBWA was issued. On 29/10/2024, next order, lordship, page number 50.
He was absent for long 5 days.
Yes, lordship. Because he was out of station, lordship, that is why. Now he will want to appear, lordship. This is an NIF case, he will have to pay, lordship. Page number 50, lordship, fresh. On that day, complainant was also absent. On 50, page number 50, lordship.
Where from you are saying that complaint was also absent?
Lordship, page number 50, lordship, next day, 29/10/2024.
No, where from you are saying that complainant was absent?
No, lordship. No, lordship, next order, lord. Page number 47. 6/8/2024, complainant was also absent. And fresh NBWS,
Maybe, he may be absent.
yes, lordship.
Hmm.
At this stage, we are praying, lordship, at least one chance may be given, unconditional apology before this honorable court, lordship. Petitioner want to appear, lordship. He was appearing all along. Only at the stage of DW, he was out of station for a few months, lordship. Next day, tomorrow, lordship.
This was Sunday. You are MS,
Yes, Kanungo, lordship.
hard MS Scanongo, লিখা আছে নামটা। for the petitioner, and also heard Mr. D.P. Kusami, the learned counsel for the respondent number.
One.
Respondent number 1. This is an application under section 528 of the BMSS against the order dated 9/7/2024, whereby the NBW was issued, and the subsequent orders dated 6/8/2024, 10/9/2024, 29/10/2024, whereby the NBW were issued against the present petitioner under the NI case number 103 of 2021, pending before the learned GMFC Kolkata, Assam. Next para, it is submitted by MS Kanungu that the accused petitioner was regularly appearing before the learned trial court below. However, on some dates, due to his some days he could not appear personally before the court, as he had to remain outside the station. And on his behalf, the petitions was also filed. But on 9/7/2024, the petition filed on his behalf was rejected by the learned trial court below, and NBW was issued against him and the other subsequent dates. She further submitted that the accused petitioner is ready and willing to appear before the learned trial court below and contest the case if he is and contest the case, and if a chance is given to him to appear before the learned trial court below, he will regularly appear and will contest the case accordingly. Accordingly, it is submitted that the NBW issued against him may be suspended, giving a chance to the petitioner to appear before the learned trial court below and to contest the case accordingly. Next para, Mr. Goswami, the learned additional PP submitted in this regard that petitioner may be given one more chance to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law. Next para. Considering this submission made by the learned counsel, next para. After hearing this submission made by the learned counsel for both sides, I have perused the case record, and it is seen that the accused petitioner petitioner remained absent in 5 consecutive dates when the case was at the stage of DW. And accordingly, considering the submission made by the complainant, the learned trial court below had to reject the petition filed on behalf of petition filed on his behalf by order dated 9/7/2024. Considering the fact that the case was pending since long at the stage of DW. Thus, there is found no irregularity or illegality in the order passed by the learned trial court below, issuing NBWA against the present petitioner on 9/7/2024 and the subsequent dates. However, for the ends of justice and considering the submission made by the learned counsel for the petitioner, this court of his opinion that one more chance may be given to the petitioner to appear before the learned trial court below on or before when it is fixed tomorrow.
Tomorrow, 28/11.
On or before the next date of listing. On or before to know the
28/11.
tomorrow, as to appear before this one, 28 so and so, which is the date fixed by the learned trial court below. Until then, the execution of NBWA issued against the present petitioner may be stayed or suspended. With time of observation, the criminal petition stand disposed of at its motion stages.
DW.
Outer line and will appear and will with a petition for regular bill, which may be considered in accordance with.
Deeply blessed.
No, no, no. Dispose of query by time.
Item 11.
May I please refer? Actually, this application is filed for crossing of PRC case number 291/22 filed by my wife under section 498A. Marriage took place on 5/3/21. Thereafter, there was a difference between husband and wife. She lost 3 cases against me. Out of the lordship may come to page annexure 1. Page 16.
I thought that this is a somewhat like NCB or BC. Then when you started that against my wife, then I just shocked how it is a case of like Kyle.
That's it.
And we on page number,
Page 16.
page 16.
Paragraph 11.
Hmm.
Considering the discussion made above and after all deliberation, it can be safely presumed that the prosecution has failed to drive home the guilt of the accused. Hence, the accused number 1 is acquitted of offence under section 498A and 323 of IPC and said at liberty. This is first case. Then one DB case was lost. That is page 21. That was also ended in compromise. Because my wife is living with me peacefully now. Is order dated 10/1/24. Page 21. Married.
Hmm.
Today was fixed for cross-examination of PW payment of cost. Both sides are duly represented. Right, joint petition in so and so. The petitioner stated that she has arrived at compromise with the respondent, hence not willing to proceed with the case. By another petition number so and so, the learned counsel for the remaining respondent sought cause for their absence, which is allowed on consideration. Heard the petitioner in person and ensured that the petitioner has filed the petition voluntarily without any outside influence and coercion. On being satisfied, the same petition being so is allowed. So this case was also closed. Now, lordship, a third case was lost by my wife that has been charge sheeted. Recently, I've been issued summon in that case. That is lordship page, next page. The order is 19/4/2022.
19?
19/4/2022.
Hmm.
That the investigation officer, while investigating the case, references found relevant materials and witnesses to establish against accused Sirajul Haq under section 498. So, case cognizance was taken and someone was issued. Lordship, but now my wife is living with me peacefully. So I come for causing of that complaint also.
Down this second PRC is under, again under
Again,
498.
498. Lordship, recently Supreme Court, in case of matrimonial cases, Lordship, Supreme Court says that if such case is filed, then court has to consider for causing of this case. Lordship. I'm referring page paragraph 32. Paragraph 32. Page 15. Very
Hmm.
good. Paragraph 32. Many times the parents, including close relatives of wife, makes a mountain out of mole. Instead of salvaging the situation and making all possible endeavors to save the marriage, their action, either due to ignorance or on account of sheer hatred towards the husband and his family members, bring about complete destruction of the marriage on tribal issues. The first thing that comes to the mind of the wife, her parents and her relatives is the police. And if the police is of panacea of all the evils, no sooner the matter reach up to the police station, then even if there are fair chances of reconciliation between the spouse, they would be God destroyed. The foundation of sound marriage is tolerance, adjustment, and respecting one another. Tolerance to each other, altered to a certain bearable extent, has to be inherent in every marriage. Pity prevails, preferring differences are
mundane matters not should be exaggerated and blow out of proportion to destroy what said to have been made in the heaven. The court must appreciate that all the quarrels must be weighted from the point of view and determining what constitutes loyalty in each particular case, always keeping in view the physical and mental condition of the parties, their character and social status. A very technical and hypersensitive approach would prove the distress for the very institution of the marriage. The matrimonial dispute, the main sufferers are the children. The spouses fight with such vehemence in their heart that they do not think even for a second that if the marriage would come to an end, then what will be the effect on their children? Divorce plays a vital play a very dubious role so far as bringing the children is concerned. The only reasons why we are saying so is that instead of handling the whole issue delicately, the intention of the criminal proceedings would bring about nothing but hatred for each other. There may be cases of genuine ill treatment and harassment by husband and his family members towards the wife. The degree of such ill treatment or harassment may vary. However, the police machinery should be restored as a measure of last resort, and that too in very genuine case of cruelty and harassment. The police machinery cannot be utilized for the purpose of holding the husband at ransom, so he could be squeezed by the wife at the instigation of her parents or relatives or friends. In all cases where wife complaints of harassment or ill treatment under section 498A of IPC cannot be applied mechanically. No FIR is complete without section 5062 and 323 of IPC. Every matrimonial conduct which may cause annoyance to the other may not amount to cruelty. Mere tribal irritations, quarrel between spouses.
But in spite of that, if she is living with you, why don't you file a joint petition?
Lordship, actually, I suggested, but in earlier cases they filed. Lordship, I made her a party. That notice we should civil appearance, we'll file application also.
Okay, she file an application, one affidavit can be,
Yeah.
if that is the position, if they are staying together, we are also not in a position
Yes.
to any impression, so. And what is the stage of the case at present?
Lordship, someone has been issued, I have been asked to appear before the court. Lordship, in the meantime, further proceeding may be strict. The next date is on tomorrow. Lordship.
Tomorrow,
Lordship. Case is pending before the Golpara court, FMC.
same, Hidigo. Heard Mr. S.C. Kyle, the learned counsel for the petitioner, and also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent number 1. Baki Nilihip, this is an application so and so for quashing so and so. Issue notice already to the respondent number 2, no formal notice is required to be served so and so. However, extra copy, requisite copy may be served during the course of the day. Next, considering the entire submission made by the learned counsel for the petitioner, the documents annexed along with the petition, and other aspects of the matter, this court is of opinion that further proceeding in respect of only one accused is there, or the
Yes,
other
no,
party.
Other has been, maybe not charged sheeted. Only husband. has
Only
been-
husband is charged. Opinion that the further proceeding if against the present accused petitioner in case number so and so may be stayed till next date of listing. Also, call for this scan copy of the LCR. List accordingly after 4 weeks.
Pending before the London Munsit number 2 comes judicial magistrate first class Golpara.
Okay, we are calling for it.
Much okay.
Wait, please, your lordship. My lord, this is regarding my lord quashing of a charge sheet as well as taking cognizance, my lord. Your lordship kindly see petitioner before your lordship, my lord, she is a junior engineer. And my lord, one FIR was lodged in long back in my lord 18/6/2011. And 18/6/2011, my lord, there the FIR was lodged, and that was charge sheeted after 12 years.
2011, the case was lost, FIR was lost.
FI was lost, my lord, and it was succeeded after 12 years, page 33, my lord. 31 is the FIR that was lost on 18/6/2011, and now your lordship come to the page 33 is the search sheet, my lord.
CS is file
On file on 29/3/2023, after about 12 years. In the meantime, my lord, the prime accused, the video, who was alleged prime accused, my lord, he died. So that's why against him, not my lord, no search sheet was submitted, my lord. I am accused number 2, my lord, page 36, your lordship kindly see. Page 36, my lord. Accused number 2, Mrs. Lotika Soikia. He is junior engineer, my lord. And page 37, has your lordship got to page 36, my lord?
Hmm.
Serial number 2.
Hmm.
And then, my lord, page 37, my lord. And she was, my lord, under section 409 and 420, my lord. My lord, she is a junior engineer. Her duty is to just to, my lord, verify the houses, whether it is properly constructed or not. That is his duty. It is monitored by the village monitoring committee. And my lord, drawing and dispersing officer is, my lord, video. So now, my lord, your lordship kindly see page 38. Page 38. Page 38, my lord. Last portion, my lord. Last but one, my lord. During the investigation, no evidence and witnesses has been found against Shri Bhakta Burman, one of the FIR arrested accused of the case, namely Mrs. Lotika Soikia, stated that Mrs. Bhakta Burman, son of so and so, is not related to the case, though he was FIR accused. Instead of him, the Gam Sevak Meji Angla was related to the case. Thus, no evidence was found against his so and so is not search sheeted. My lord, this is the statement of the accused. That cannot be a part of the search sheet. Latest judgment of the Supreme Court also, my lord. The statement of the accused cannot be a part of the search sheet, my lord. I am not on that mind, just my lord, because last 12 years, my lord, there are 9 IO has been changed. And my lord, probably lack of knowledge, my lord, that was been in the mind. Now, I am not on that, my lord. Your lordship kindly see page 49, my lord. Page 49. This is the brief fact of the case, my lord. Oh, my lord, again, before that, my lord, your lordship kindly see that video. Page 39, my lord. Page 39, my lord. That, my lord, block letter portion, my lord. During the investigation, one FIR arrested accused, the case of namely Sil Lotika Soikia, stated Mr. Babul Bora, former BDO, Rongkhang block, PS so West Bengal, Assam, died in an accident, thus he is not search sheeted. Again, my lord, statement of the accused is there, my lord, but he died, my lord, that's why BDO, my lord, he was not been search sheeted, my lord. Now, my lord, your lordship kindly see the fact of the case, my lord, that is page 49, my lord. Brief fact of the case, that complainant rising so and so lost the FIR Poithalangso PS inter alia, stating that the work under Poithalangso block was shown as executed by the job card holder village so and so, Kashmir so and so, and so, the wages were shown as a paid in cash, and the card holder which were recorded in 24/9/2009, but the practice, if the practically job card holder had not received any money, the entire amount was fraudulently withdrawn by BDO Abdul and J. Lotika Soikia, along with members of the village monitoring committee with Nangthang MSC constituency. So, my lord, that is the brief fact of the case. My lord, I am not the dying and dispersing officer. I am not the junior engineer. My duty was only to feel, my lord, whether house was constructed properly or not. That is my official duty. So now I am coming to this, my lord, because, my lord, without taking any sanction from the competent authority, 197, your lordship kindly see sanction has been not taken, my lord. That is your page, page 49, my lord. Serial number 15. whether prosecution sanction is required, obtained or not, if yes, that is keep blank. Now, my lord, I am discharging my official duty, although that 409 will not come to me because it is not entrusted anything, my lord. Now, my cognizance has been taken, my lord. So, your lordship kindly see page 51, my lord. Page 51, my lord. Page 51, the case record is put up along with the case diary, other police report, etc. Where is the case record? It is seen that the search sheet has been filed by so and so against the following accused person. Finding prima facie case on the aforementioned offense against the accused person, the cognizance has been taken for necessary trial. Very interestingly, my lord, the CS accordingly, CS accepted accordingly. First, my lord, CS accept, then my lord, cognizance has been taken. But my submission before your lordship, without any sanction, my lord, cognizance has been taken, my lord. So that's why, my lord, it is there. Cognizance can be taken at any time, but my lord, sanction can be taken any time. But without taking sanction, my lord, no cognizance has been taken, my lord. That is the law, my lord, and my lord, recently the Supreme Court also very clearly mentioned, and similar situation, our High Court also passes judgment.
But is it a offense which she was while discharging her office?
Yes, my lord. And could not have been, my lord. I was an engineer, my lord. My duty is the that allegation is that, my lord, that going and that amount is done by video, and since now video is not there, my lord. Video is died during the investigation, my lord, and my duty is on the field, my lord, and that is monitored.
Yeah, you were supposed to monitor the construction work, but
Yes,
have
my
you?
lord, but there is no
Without
allegation
any
that houses are not constructed. The event, and that is my official duty, my lord. So otherwise, my lord, since I am a junior engineer, I am doing the official duty. That's why, my lord, I am in the affair, I am in the search sheet, my lord. So my submission before your lordship, while discharging, there is a reasonable connection. Your lordship kindly, and all the judgment says that there is a reasonable connection with the works done by him. Then sanction is required. So that's why I am submitting. Sanction is required in this case. No sanction has been taken till today. So cognizance taken by the learned trial magistrate is, my lord, wrong. That is my submission. My lord, your lordship kindly page, that is, my lord, 2020-27 SCC 695. Judgment edition. Then that judgment probably para 76 and 77, my lord. And our judgment of our High Court, that is very in a similar situation against the video. Our judgment. The another judgment of our High Court, my lord. That is the judgment of our High Court, my lord. The situation is similar. That's why I am placing it, although it is an old judgment, my lord, and in 1992 criminal law judgment. Para 6, 7, and 8, my lord. Para 20, 14, 15, my lord. 14, 15, and 16, my lord.
Yes, good.
Sir, I have noticed that for record, maybe control with this regular record lordship and along with the case diary also. Lordship will decide on
Case diary.
along with the case diary. Record may be called for along with the case diary.
Case there, that is already before the court.
Before the court, lordship.
So, my lord, already cognizance has been taken. That's why, my lord, that the my lord, the petitioner before your lordship, my lord, he is a dialysis patient. Day to day, he has to die dialysis. My lord. So, for him to face the trial is very difficult, my lord. So that's why I am submitting, my lord. I am there for only for certain period. In that Karbi Alang, my lord, I am for a certain period only.
Within this certain period, you
But,
have accumulated such.
That your lordship kindly see 2011. I was in 2009. So FI was in 2011.
So
And
nine
search sheet
to- you are in 2009.
9, my lord. But even then, my lord, during, probably, my lord, there is no specifically that during this period it has been happened. But while I was there, my lord, regarding construction, there is no complaint, nothing, my lord. And regarding disbursing, my lord, how can I, my lord? Only allegation that, my lord, that's
That's why you are with that video. Unfortunately, he died.
my lord, he died, my lord. So my submission before your lordship that, my lord, that taking cognizance is absolutely against the law. So, my lord, yes, they can start, my lord, taking the sanction from the government. That cannot be, that can be done, my lord. But till today, there is nothing, my lord. No sanction, my lord. So I am protected under 9197. Because work which I have done, there is a reasonable connection with my official work, my lord.
And Mr. T.J. Mahanto, the learned senior, T.J. Mahanto, the learned senior advocate, assisted by Mr. R. Bora. Mr. R. Bora for the petitioner, and also heard Mr. D.P. Goswami, the learned additional people appearing on behalf of state respondent. This is an application under section 482, again CRPC, 482 CRPC for washing of the impugned FIR dated 18/6/2011. And impugned charge sheet bearing CS number 29 of 2023, dated 29/3/2023, filed in connection with Boithalangsu Police Station case number 32 of 2011 under section 409 of 420 IPC, and the order of cognizance taken by the learned magistrate dated 11/5. Cognizance was taken on which date?
11/5 to 2023.
23, 11/5/2023. Next, for issue notice to the respondent number 2 to register DD as usual process. Formal notice is required to be served on respondent number 1. However, extra copies may be served during the course of the day. Petitioner will take necessary steps within 2-3 days. Next, we have Mr. Mohanto, the learned senior counsel, further submitted that the present petitioner was working as a junior engineer at the relevant point of time when the FIR was lodged in the year 2011. And it is also seen that the charge sheet was filed after 12 years lapse of 12 years, that is on 29/3/2023. From the FIR itself, it is seen that stop. At the relevant time of incident as a junior engineer, her duty was only to supervise the constructions work in the village, and she was not a DDO. And the drawing and disbursing, not a DDO, and she was not a DDO, and not a DDO. Full stop. More so, he submitted that till the date of taking cognizance, no sanction has been obtained for prosecution to prosecute the present petitioner.
50 of 2000.
Though it is clear from the CS and the FIR that there is a reasonable connection between the work and the allegation brought against this so and so, and hence this sanction is required. But without obtaining any sanction, the charge sheet was filed and even the cognizance was taken by the learned trial court below. In this regard, he also relied on one decision of Honorable Apex Court, passed in criminal appeal number 458 of 2020, arising out of SLP bracket of criminal of 1882 of 2018, and emphasize on para 16 and 76 and 77 of the seat judgment. Wherein also it is observed by the Honorable Apex Court that the criminal procedure that application under section 482 CRPC is maintainable to quash proceeding which are ex facie bad for want of sanction, frivolous or abuse in process of the court. Mr. Mohanto, the learned senior advocate, also relied another decision of the coordinate bench of this court passed in CR number S bracket dot K of 1991.
Five, not S5. 5 indicate K.
Oh, sorry, 5 bracket dot K of 1991, dated 15/7/1991. And emphasized on para 14, 15, 16, and 16 of the same judgment. Next part, considering the submission made by the learned counsel for the petitioner and the proceeding against the present petitioner be stayed till next date of listing.
That is, your lordship kindly mention the PRC case number 150 of 2023.
Yes, PRC case number
Deep-
3. So we'll mention the case.
My lord.
Okay.
Deeply. Deeply.
Also call for DLC, scan copy of DLC.
Deeply.
কালিও আছে চাগে ইমান বিলাক কি কৰিব এইবিলাক কৰি পেলাই সেইকাৰণে মই লাহে লাগি আছো Yes, 13.
My lord, in a NIA case, my lord, under 138, my lord, the present petitioner, he missed 2 dates, my lord. But on both the dates, his counsel was there. But on the second date, my lord, NBWA has been issued, my lord, page 21, my lord. Order dated 25/9/2014. This NBW was issued and the next date is fixed on 10th January 2025. So, my lord, I only pray my
NBW was issued on 25/9 or in earlier date also.
for 25/9.
Now you're saying that he was absent in 2 days?
2 dates, my lord. Earlier date, my lord, council represented, my lord, that was allowed, my lord.
Okay, where is the order?
That order is not available, but from this order, lordship can see, my lord. Complainant is present, accused persons are absent with step white petition number so and so, showing cause that learned advocate for the accused could not contact him and hence files this adjournment petition. The wakalatnama is also not filed by the learned advocate for the accused. It is seen that the accused took adjournment on the previous occasion also. I am not satisfied with the petition filed by the learned advocate for the accused and hence rejected. Issue NBW against the accused. The complaint takes care. Now, my lord, I only pray to keep this NBW in abeyance till 10/1/25, that much.
Can you find the orders? At least 22nd March order is filed. You have an annex.
So 22nd
The order
March is there, my lord. 22nd March is there. Kindly come to page 15, my lord. That is the type copy. 22nd March, I have annexed. 23/11/23 also I have annexed. W as well. BW was there, my lord. 23 March, page 15. Then
But
25/7.
if you come to page 14, that is the order dated 23rd of November.
Yes, my lord.
On that day, the cognizance was taken.
Cognizance taken and 22/03/24 was fixed for appearance. And 22/03/24, the accused was absent, so BWA was issued. Then next date was fixed on 25/7/24. On 25/7/24, petition was preferred, my lord. That is available at page 17, my lord. 17. This petition was filed, my lord. On 25/7/24, date is mentioned there, my lord. Filed by Abhijit Mena advocate on 25/7/24. And at para 2, it was mentioned that the accused person is suffering from slip disc
and he is advised by doctor to take bed rest. As such, he could not travel from Punjab and as such could not appear before Honorable Court today. And prescription was also enclosed, my lord. Inadvertently, my lord, we did not give the order. What is the order? 20.
You do allowed or rejected, nothing is there. Have you, do you have the order,
25/7.
the previous order?
25/9. 25/9.
Give the order.
I'll just check, my lord. 25/7. My lord, 20, actually, my lord, 25/7 NBW was not issued. Clear
How can we say, just take us, the order is required, that much only.
25/7, my lord.
If you want, then we can fix it tomorrow also, collect the order sheets.
My lord, tomorrow, my lord, you cannot get the certified copy. It is, my lord, next Monday, my lord.
But date is fixed on when, in the month of January?
January, my lord.
January. Okay, then we are listing it on Monday.
My lord.
Try to file the order because
My lord,
we
we'll
don't
get the
have any order.
Certified copy, my lord.
This Monday, and I bring the petitioner side to file the certified copy of the orders. To an additional affidavit you are going to file?
Yes.
To an addition. Monday is which date?
Obliged, my lord.
14. Okay. It's filed by state?
Yep.
उनका क्यों लिख लेते थे filed by the state देखो ना it to keep 15 to PP का नहीं एक भी नहीं दिया
So, here's some kind of.
you have filed this one
Yes, lord.
anyway for cancellation of bail or what?
The record is not available.
The record is not available. Okay, you seek time sometime.
So, even as not for next week, we'll do it.
Next week.
Next week also. So record is not
List.
available, we have to wait to find it.
List after Monday.
Oh, I think I have.
50.
Here is bail application, Your Lordship. Already charge sheet and case showing the petitioner is absconded. Your Lordship directed the petitioner to appear before the court below and to file a regular bail application. Lordship, the cognizance has already been taken and summons has been issued. Now the petitioner is apprehending arrest the moment he appears before the learned court below. The learned court below will take him into custody. The Lordship will find the FIR at page 19. Where is the FIR, Lordship? The accused named in the FIR serial number 1 is the petitioner before Your Lordship.
Number 1.
Yes, Lordship. Deepak Chauhan. সম্পর্ক বিনীত নিবেদন নিজে যোৱা 20/12/2000 ইমান তাৰিখে প্ৰায় 9:30 মান বজাত মোৰ ভাইটি সয়ঞ্চু ফোনযোগে মোৰ ছোৱালী সয়ঞ্চু শাৰীৰিকভাৱে অসুস্থ বুলি জানিব পাৰো আৰু মোৰ ল'ৰা শ্ৰী সন্দীপ চৌহানক লৈ মোৰ ছোৱালী মমতা চৌহানৰ কিষাণ বস্তিত থকা ঘৰলৈ আহোঁ আৰু খবৰ কৰি আহি জানিব পাৰো যে মোৰ ছোৱালীজনীৰ মৃত্যু হৈছে আৰু ছোৱালী ঘৰৰ ওচৰৰ মানুহৰ পৰা জানিব পাৰো যে মোৰ ছোৱালীজনীয়ে চিপজুৰি লৈ আত্মহত্যা কৰিছে মই সাক্ষীৰ সহকাৰে উল্লেখ কৰোঁ যে মোৰ ছোৱালীক শহুৰেকৰ ঘৰৰ পৰা ধন সম্পত্তি দিয়াৰ পিছতো বহুত যৌতুক দাবী কৰি আছিল আৰু ওপৰত উল্লেখিত পদকীয়াগণ ইয়াৰে পিছৰ পৰা শাৰীৰিক আৰু মানসিকভাৱে অত্যাচাৰ কৰি থাকি আত্মহত্যা কৰিবলৈ বাধ্য কৰাইছে 1 নং আসামীজনে মোৰ ছোৱালীজনী শাৰীৰিকভাৱে অত্যাচাৰ কৰি থাকে আৰু প্ৰাণী মৰা ভাবুকিও দি আছিল বুলি জানিব পৰা গৈছে 5 নং আৰু 6 নং আসামীজনে 1 নঙৰ লগত জড়িত আছিল Here the accused number 4 is the husband of the deceased, Lordship, so Eddie's victim. And he has already been granted bail. 2, 3, 4 were arrested and already granted bail by the learned court below. And after completion of the investigation, Lordship, the charge sheet has been submitted. Your Lordship will find at page 28. Charge sheet is submitted under section 498A, 306, 304B, and 34, read with section 4 of the Dowry Prohibition Act. At page 31, serial number 5, at the bottom of the page, my name is there, Lordship. Shri Deepak Chauhan. So though the charge sheet is submitted under various sections of IPC along with section 4 of Dowry Prohibition, at page 32, your Lordship will find serial number 10, 11, 12, 13, 14, 15. Under X and sections, section 306 IPC. So there is no allegation of dowry or
No, whatever it is will come later on. Now your petition, you say you are absconding.
yes. Now, your Lordship may kindly see page 36 for a moment. The allegation against me, Lordship. Prima facie, there is no material of 306. Police has not submitted charge sheet under section 304B against me. At bottom of the page, Lordship. The last paragraph. During investigation, one blue color floral dupatta, one red and white color check, Bihari gamucha, and one mobile phone of the deceased wearing so and so, which was produced by the husband of the deceased Sri Gama Chauhan, so and so, West Carbino, and one super splendor bike bearing registration number demanded as dowry in the time of marriage from Gama Chauhan, Sri Sriram Chauhan, so and so, one pen drive. The allegation against me is that one pen drive, red and SanDisk, red and black color 16 GB, where one number of video found in the mobile device bearing so and so of the deceased, which was sent from the deceased woman's mobile to Deepak Chauhan through WhatsApp, which was extracted and produced by Constable so and so. And thereafter, serial number 5, one pen drive containing the victim WhatsApp chat with the accused Deepak Chauhan, which was exported and transferred by so and so, seized in presence of the reliable witnesses. So the only allegation is against me is that the deceased had sent a video in my mobile phone. So how can I be charge sheeted under section 306 for abatement of suicide for someone who had sent a video on my phone?
But in the FIR, you are the main
No,
person.
FIR in
who-
the
Yes.
yes, the after investigation nothing has been found, and therefore there is no allegation
We are
against.
not going to the merit of the case at present. Now you are showing as an absconder,
Yes, Lordship, may
isn't it? Yes, then.
call the LCR in that case.
Yes. So after the charge sheet, have you received the summon or
Yes, Lordship.
you have received
Yes,
some?
I have annexed the cognizance order also, Lordship.
So you are not the husband. So who are
No,
you?
I
in
am not
fact?
the husband. I'm the cousin of the.
So place 44 of the source.
And I in fact do not reside with the alleged victim and the husband of the alleged victim. I reside in a separate household.
We are it from the top 3 lakhs, top
Hmm.
last 3 lakhs.
Hmm.
But 1 year after the marriage, Mamata and her husband was beaten by the nephew Deepak Chauhan and his mother Kaushal Devi. But the family of the victim went to their house and settled this dispute. After that, when Gama Chauhan had got a golf-granted house for 1.5 lakhs and for construction of his house, Gama Chauhan demanded 30,000 from his father-in-law, complained and received the money from him. It is also found that deceased victim Mamata Chauhan also had an affair with her husband nephew Deepak Chauhan, and they always called and video called with each other through WhatsApp.
Yes.
But Deepak Chauhan's mother, his uncle Indal Chauhan, announced something to blame Mamata that she is 1 lakh rupees from Deepak Chauhan. Due to this reason, that part is 1 lakh. After that, during investigation, the third paragraph, CDR of the Deepak Chauhan, number so and so, Mamata Chauhan, number so has been collected. By analyzing the CDR, it is found that the number of Mamata Chauhan was using the registered Gama Chauhan from address so and so. Number telephonic conversation of the police petitioner and the victim, this is victim lordship. So some connection was there lordship, so automatically materials against the petitioner was there lordship. That's why the suspect and
Okay, we
record
call for the
record
case
record.
record. Let's see it. Simply record for Hard Mr. R for so and so. It's an application corridor, call for the case record. No, you have made, only state is the party.
Yes, yes.
Okay. No formal notice is required to be submitted here and, call for the case. record. When it can be listed, no, after 2 weeks?
Estimate can be
List up.
fixed a date,
Huh?
if a date can be fixed.
After 2 weeks, any date? Then actually, we don't have such dates. In fact, all our 16, 12.
Yes, published.
Item 60.
Yes.
Nowadays. 83. But I take the lawsuit to FIR, man, page 14. But what happened?
1-4.
1-4.
Hmm.
The FIR was lodged by the police officer of the Thelamara with the allegation that they found the 19 grams of bitumen in front of the shop of the Nath Dhaba at Thelamara, Ghatua. Now, my lord, accordingly, it was seized. And my lord, on suspicion, they have arrested one person, my lord. His order I have given, my lord. His name is, my lord,
Join up.
Jainal Abedin. My lord, interestingly, my lord, I take your page 18. Kindly, what is the order of the magistrate? He even, the IO has approached that to saddle the accused with necessary conditions so that he can cooperate with the investigation. And till now, no owner of the bitumen has been found out. Now, my lord, I am residing in Arunachal Pradesh. Police, he might have told my name. The police came to my house. My wife sent a message to me that you are to police is searching, you come. I have come. Now, my lord, then I applied for the copy. I found that my name is also not here. But police is searching me. I want to go, my lord. Now, my later on inquiry, we come to know this bitumen is tagged by a national highway contractor to work for the repairing work of me. Now, so my it is being already noticed. It is not a stolen property. There is no owner. Then the owner has now come up on our inquiry. It has been tagged by the contractor, my lord. So till I am apprehending to go to the police station. That's why I am before your lordship. Kindly call for the CD, my lord. If anything they are against me, then kindly protect me till then, my lord.
Case diary may be called for with this case. So going to the case diary, if you are going to the case diary, you cannot say anything also.
The case diary, I am paying for case diary. Kindly protect me, my lord, because the order of the landed magistrate in page 18, you should have everything will find out. In response to my query, the order dated 3/10/2020, IO has submitted that he is yet to find out any clue regarding the ownership of the seized bitumen. As regards the one Tapajul Hawk, IO has submitted that though his name was disclosed by the co-accused Jainal Abedin, his whereabouts is not known. I am still in Arunachal Pradesh, how they will get my. So, my lord, switch off. The IO has thus submitted the investigation is not yet over. On the bail application, the IO has not objected to the same and requested to saddle the accused with necessary conditions so that he cooperates with the investigation. Unnecessarily, that man was arrested and detained for long period inside the jail, my lord. Anyway, my lord, I am not for him. I am for this proposal now.
So your name is there in the order of, reflected in the order of passed by the learned trial court.
It is come because the co-accused, it is the on query he has submitted before the IO has submitted that one Tapajul's name has been disclosed by this accused. Tapajul is in Arunachal Pradesh. And my lord, this tag was done few days ago by unloaded by the contractor. And in front of the dhaba, the Nath Dhaba in Thelamara Center. So it is not a stolen property. Now nobody has tagged it.
Better to call CD, I think. You're calling for the CD.
Kindly
Let us
protect me,
call
my lord, till that protection. My lord, I have not done anything, but kindly bear with me, my
You
lord.
have not done anything,
But
but.
my lord, my remand will be curtailed. I will go to the police station. He will put me behind the bar. And earlier
No
that
need,
man was
we are
there.
just calling for the case diary. Till then, somehow you manage. We'll see. And we'll call in for the case diary. We'll try to give a short date. Where from it has to come?
Thelamara, Thelamara.
Thelamara, Sonitpur.
So
Yes, prior to vacation, any date, short date.
total 9/12.
9/12. We're fixing it on 9/12. Call for the case diary. 9/12.
Kindly protect me, my lord, kindly. Bear with me, my lord. I have not done anything, my lord. This, our liberty is stake, my lord. That's why.
We'll go for the case diary, then we'll see.
I
What-
cannot
what-
stay at a home, my lord. That is the problem. I have come from one of the bona fide. On call, I have come.
Okay, we'll see.
Timing for
Timing? Even time like you said, is in the account.
Item is exactly as item number 12, just now your lordship has passed the order, I am also junior engineer, my lord. In item number 12, your lordship has passed, my lord.
Junior engineer of that.
Junior and
Logic-
that-
Logica Soikia lordship.
No, there is Lotika Soikia, and now we are here, Kamala Borua and two others.
Out of same FIR?
Same, no, yeah, same, actually same, my lord. The FIR
No, exactly same. I'm not asking.
Yes.
Out of same FIR?
Case number is different. FIR is at page 18 and case number is different. Registration of number, but everything is same.
Charge sheet submitted already.
That's it submitted and cognizance has been taken. FIR is at page 16. With due rigor, it is to be mentioned that on last 2008-9 and 2009-10 financial year, the government sanctioned substantial amount of money for doing development work in the block Ronghang development block under NREGA scheme. Later, the major portion of sanction amount was misappropriated by the block development officer, junior engineer, employees, and other officials of Ronghang development block. So these are the same allegation also there in the item number 12, my lord, that FIR. And also here BDO was not charged. He is the authority. We are the field staff, executive engineer. And
Same
no
video was.
same video, Ronghang
He
development.
died.
Ronghang development block.
No, anyway, he died.
On that case, BDO was expired.
On that case, he died.
But here we do not know he died or not, we do not know. BDO was not, my lord, implicated in the case. And he is the authority, sanction authority. BDO is the drawing and dispersion authority. We are field staff. We have to work in the roadside, man. We are engineer. No sanction has been taken till date, man. So whatever amount, 4099, my lord, we were entrusted with the property and all. If it is, my lord, the road is constructed also, how can we bring it? Because money, whatever it will drawn by the BDO only, not by us. The 409 directly ingredients, not 3 ingredients are applicable, is fulfilled, my lord. Simply our name, they has been picked up in the chart sheet. In the FIR also, we were not named. In the just chart sheet, it has been picked up. Chart sheet, you will also page 50. No statement, statements are recorded from page 47. Nowhere our names are there. Nowhere. That 1 to 11, sorry, 1 to 13 is the statement of those witnesses, important witnesses. Now, how we have been named in the chart sheet, we do not know. Because our names are not disclosed there. Moreover, no sanction is there till date, my lord. Your lordship has just granted, my lord, that the prosecution, further proceeding has been suspended by your lordship. As per so, no sanction has been granted till date, my lord. The case of 2011. Call for this. Yes, same, exactly same. Only the case number is different. PS case, Bochalamsu PS case number is different.
On that part.
Item
12. Who did it? He was. Here also FIR was lost in 2012.
Yes, ma'am. Yes, same, exactly same, ma'am. Only case number, PS case number is just different. Because persons are different.
CS when CS was filed?
CS was filed on, my lord,
9/3/2023. 19/3.
19/3. 23. It will he was CS filed on 19/3/23. And FIR is at 9/8/2011. 9/8/2011. Baki Okoman submission did you, Mr. Swenso, submitted in this regard. That the present accused petitioner Izan was working as a junior engineer at the relevant time of incident
Then retired. Petition number 2 and 3 are retired now.
already.
Already.
How many petitioners are here?
Three petitioners.
Out of out of 3 petitioners, the petitioner number 2 and 3 also got retired. First, on the DDO was the drawing and disbursing officer, and the present petitioners were no way related in the misappropriation of any money as alleged in the FIR. Their duty was only to supervise the work of development, which was and work of development as which was entrusted to them. And baki khine ke hoga. Okay, your state.
Yes. Obliged. Highly obliged.
Number 4. One here and from its start. 22. For bail hearing, item 22. Yes, you have received?
Lord.
Yes, Dad.
Let's take one. Scan copies, Lord.
Scan copy. Okay, translated. Okay.
Dear Lordship, the petitioner was arrested on 3/2/2022.
3/2/2022.
Charge sheet was submitted on 26/6/2022.
26 is 2024.
26/6/22. Yes, Lordship. Charges were framed on 21/9/2020.
21.
9/2020. In today's PW1 was examined on 3/5/2023. 2 was examined on 12/9/2023. 3 was examined on 8/11/23.
8/11.
8/11/23. And 4 was examined on 16/2/2020.
Out of 8.
Out of 8, Lordship. Basically, Lordship, I am seeking bail, Lordship, on the ground of undue delay. Last witness was examined on 16/2/2024. Since then, Lordship.
23 or 24?
24, Lordship.
24.
And next date is Lordship 19/11/24, which was one of
Next date is, Lordship, I think 19.
19/11.
19.
Can you
Can you
No.
tell us regarding the 19/11? Is there any progress?
No, Lordship. No witnesses were with the Lordship on that day also. Lordship may kindly come to the additional affidavit which I have filed, Lordship. I have annexed the order sheets. I'm not going to read out each and every order. But Lordship, I will read one particular order, Lordship.
Additional.
Yes, Lordship. My Lord, may kindly come to page number 87, running page 87.
87.
Yes, Lordship.
Yes.
Order dated 6/5/2022.
Hmm.
Both the accused persons are physically produced before me from judicial custody. They are further remanded to jail custody. PWs are absent. Summons did not return. At both the sides, Perus here. The record reveals that out of 6 witnesses, 4 witnesses are examined. Actually, Lordship, it is 8 witnesses. 4 witnesses are examined. Last PW being examined on 16/2/2024. Thereafter, no PWs has been produced. Record reveals that the accused in jail since 3/2/2022. In view of the above, as only 2 witnesses, including it should be Lordship 4, including so and so remaining to examine, prosecution is directed to produce the witnesses on the next date without fail. To procure the attendance of the PWs, necessary steps be taken through the BIC, fixed on so and so terms. Thereafter, my as much as Lordship, 7 dates have called, Lordship. That was lordship 3/6/24, then 9/7/24, then 28/24. Once again lordship 12/9/24, 23/10/24, and 9/11/24. 19/11/2024. No witnesses have come in my lordship. I'm not going to the merit of the case, lordship. My only ground is lordship, the undue delay, lordship. Undue delay in the trial, lordship. In this regard, lordship, I'm relying on certain judgments, lordship. The first judgment, lordship, which I am relying on, lordship, of our court, lordship, BA number 44 of 2024. My lord, lordship,
These are all from Koidner benches.
Supreme Court judgments are also there, lordship.
Prakash.
Yes, lordship. Zakirul, Ravi Prakash, and Ankur. These are the Supreme Court judgment, lordship. Three Supreme Court judgment and lordship. And this judgment, lordship, which just now I have referred, PA number 44 of 24, the order dated 21/6/2024. I'm relying on page number 6 to 24. Here, lordship, all the judgment of the Honorable Appellate Court, lordship, starting from Ravi Prakash, you, lordship, Ankur, and Zakirul, everything has been discussed, lordship. All the judgments have been discussed, and finally, lordship, on the ground of undue delay, bail was allowed, lordship. Lordship, may kindly come to the paragraph number 20. I'm reading only one paragraph, lordship. All the other judgments, lordship, which have been referred earlier, including Shariful Islam, I'm not reading all those, lordship. In the instant case, the present petitioner has been detained. I'm reading paragraph number 23. Has been detained behind the bars for more than 1 year and 7 months, and not even a single witness has been examined till now. Under such circumstances, in view of the observation of the apex court in various rulings cited herein above, this court is of the considered opinion that under the facts and circumstances of this case and the period of detention undergone by the present petitioner is long enough to outweigh the embargo of section 37 of the NDPS Act 1985, and the petitioner is therefore entitled to bail on the ground of prolonged incarceration. Now, lordship, may kindly come to the next judgment, lordship. 2979 of 23, order dated 11/12/2023. Here also, lordship, on the ground of prolonged incarceration, lordship, referring Ravi Prakash's judgment, bail was allowed, lordship. Paragraph number 6, lordship, I'm relying on. Ravi Prakash has been referred, and then, lordship, I'm reading paragraph number 11, small paragraph. Considering all aspects and in view of the foregoing discussions, and also considering the fact that not a single witness has been examined despite the fact that the petitioner has been in jail since last 409 days, petition is allowed. Once again, lordship, that is on the ground of undue delay. Now, lordship, may kindly
Okay, yes, please.
What Honorable Supreme Court judgment, lordship, the delay cannot be ground in a NDPS cases in regards to commercial quantity, lordship. So we provide the judgments for your lordship. So give us some time, we'll produce the judgment, lordship, before it.
Well, these are the judgments he relied on. He is of only
Delay ground.
period of the
Detention.
incarceration only,
yes, sir.
and you are going to produce another judgment.
Then, lordship, my learned friend will place the judgment, lordship may pass over.
Lordship,
Till then, what do you have said?
I have said that, lordship, my learned friend will place the judgment, lordship, and lordship will pass the order.
How many bail matters are there? Right, defense. I think so.
My lord, I have a small prayer in respect to item number 17, admission matter, my lord. LCR, scanned copy of the LCR has been received, and there is no stay order of the pending proceeding before the trial court. May I pray, my lord, this matter may kindly be taken up on any hearing date, will net hearing, either on 3rd of December or 5th of December. And
My lord,
17, my lord.
I appear for the respondent number 2, my lord. We have entered appearance today. So my lord, we need some time to file objection, my lord.
It is a causing petition, my lord.
Yes, my lord. 7.
Well, there is no stay, my lord. That is the difficulty. May it come up on 12th of December, my lord, then. 12th of December, it can be disposed of. Because there is no
My lord.
interim, my lord.
My lord, that's why, my lord, the client is staying in Hemazi, my lord, so it will be difficult to get it drafted and thereafter vetted and thereafter file it. My lord, can it be later, 3rd week of December?
There will be holiday from 20th. It will be a motion day.
My lord.
My lord, there is no stay. Initial order was passed on
My lord,
17th.
in fact, my lord, already LCR is there.
Yes,
So lordship can hear the matter
yes,
if I
yes.
file my
That is, I
objection.
am praying.
That's why, my lord.
On 3rd of
Today is
December,
the
it can
first
be
time
heard,
I'm
my lord,
hearing, my lord.
without any objection. It is on a law point only.
Objection, my lord. That's why, my lord.
Since
Sometime at least 3 weeks.
LCR is there, we can make a submission only.
No, I have to file my objection because, in fact, the copy is also not there with me. 16, 12.
My lord, can it be on
28.
20 is the last day? It will be,
No,
my lord, may it be on 12th, my lord. It will need
16,
hearing, my lord.
16, my lord. 16.
Oh, in IA, actually,
In
Yeah.
IA, for the
IA,
applicant,
otherwise you are for the respondent. At the request made by the learned counsel for the respondent, you are MS
and Kolita.
and Colita. With the, no, sorry, with the consent of the other side. The learned counsel appearing for the respondent, MS and Kalita paid for an adjournment, to which the learned senior advocate, Mr. Sisir Doctor, raised no objection. List accordingly.
Your lordship.
9th of January will do,
oh, let they are choosing that date, no problem.
9th of January. Okay, we are
God bless.
fixing
24.
9, 20, 25.
The coordinate bench of this honorable court has already dealt with the bail application of co-accused matter. It has already been disposed.
24.
Item 24, madam.
Ah.
So this may come up before the appropriate bench. For co-accused, already dealt, my lord.
It was before the other bench.
Other bench. Justice
Acha.
Eli Chaudhary. I am giving a other copy of it.
It's okay, you have submitted it.
For co-accused, madam.
For co-accused.
Madam.
Acha. Out of same FIR? or not?
My lord, send it.
Considering this submission made by Mr. UK Borman, the learned counsel for the petition. List the matter before appropriate bench. When any list you want to any date,
madam.
any date?
On, it may be come out on 12th, madam,
12th of December. 12th of December. Okay, we are fixing it on 12th.
Okay,
Okay.
sir.
27.
This is the lordship. My 483 application, Malad. Earlier, we approached this audible court. That was rejected by the audible court, Malad, as we argued that non-compliance of section 50. Lordship's rejection is at page 35. And it was rejected on 4/2024. Now, Malad, our sole ground in this application, Malad, we have taken is the prolonged incarceration, Malad, as the pressing ground for considering my bail application, Malad. In this case, Lordship, I was arrested on 26/8/2022.
26/8.
Yes, madam, 26/8/2022, madam. And charge sheet was laid in this case on 30/10/2022, madam, citing 11 witnesses by the prosecution, madam. And madam, charges were framed on 22/02/2023, madam. Yes, madam. And thereafter, madam, the first prosecution witness was examined on 6/6/2023. Then it was madam PW2 who was examined on 20/06/2023. And madam PW3, I'm sorry. And PW3, he was examined on 18/7/2023, madam.
18/7.
18/7/2023. And thereafter, madam, after almost 13 months, 1 year, 1 month, the PW4 was examined, madam. 6/9/2024. I have annexed in my petition, madam, page 30.
6/9.
2024.
24.
24. The last witness, madam, PW3 was examined on 18/7/23, and thereafter, madam, after 13 months, he was examined, madam. So in this way, madam, I have been in custody for 2 years, 3 months, 1 days as on today, madam, which stands at 824 days. Madam, in this case, there is, madam, my humble submission is that, madam, from the progress of the case, it cannot be said that the trial will be culminated soon, madam. So considering the prolonged incarceration, madam, my humble prayer for the Honorable Court to consider the condition and liberty of the present petitioner, madam. And further, madam, I'm a local resident. I reside within the jurisdiction of the special court itself, madam, Karimganj. So I will, madam, face the trial. There is no chance of, madam, absconding or not facing the trial. And Lordship, I will abide by any condition in the event Lordship imposes, madam. Any stringent condition, madam. So, Lordship, madam, in this regard, I have prepared one small comparison for Lordship's perusal, if I can hand it over.
In this period, Lordship, my knowledge can rightly stated, PW1 is examined 6/6/23, 2 is 26/23 with the driver of that auto rickshaw. PW3 was examined on 18/7/23 and PW4 is 6/9/24. So my humble prayer is that Lordship, trial is going on regular smooth manner, Lordship. So out of 11, 4 years ago, you have to already examined, and 7 is yet to be examined. Next date is 10/12/24.
Last examined on 6/9/24, and then, my lord, after 3 months, date has been fixed. This also Lordship can visualize that trial, the culmination of trial will take some reasonable time, my lord.
But in the Lordship, in September, until cases, Lordship, when Honorable Supreme Court so rightly said, under trial cases, which charged with an offences under the Act punishable with minimum imprisonment of 10 years and a minimum fine of ₹1 lakh. Such an under trial shall be released on bail if he has been on jail for not less than 5 years. That's rightly clear, point not about the truth.
That is, my lord, if I'm not wrong, that is in respect of 436A, my lord. If anybody has, my lord, that cannot be said that somebody has to complete 5 years, then his right will be there for pressing bail. Now, my lord, if the Lordship peruses the compilation, my lord, these are the persons who were facing trial under the NDPS Act. And considering, my lord, the progress of the trials, particularly, my lord, 1 year, 6 months, 1 year, 7 months, Lordship will find, my lord. And another aspect, my lord, the no criminal antecedent. In my lord, Nitish Adhikari, page 7, Lordship will find the Supreme Court also took into consideration there that the person has no criminal antecedent. Page 7, my lord, of my compilation. May I read, my lord, that paragraph, page 7. During the course of hearing, we are informed that the petitioner has undergone custody for a period of 1 year, 7 months as on 9/6/2022. The trial is at preliminary stage as only one witness has been examined. The petitioner does not have any criminal antecedents. So that was one of the criteria, that not having criminal antecedent and my lord, prolonged incarceration. Coupled with prolonged incarceration, the Honorable Supreme Court granted bail. Now, my lord, these judgments, other judgments, Lordship has already my lord, gone through in various other orders. Now, my lord, I request your Lordship to peruse page 16, my lord. There is very recent judgment of Honorable Supreme Court, where a person may read, my lord. Page 16. The petitioner is charged with offense under section 20 B2C of Narcotic Act 1985. She is in custody for a period of 2 years. Though the trial has progressed, only 5 witnesses out of 10 have been examined as of date. May I read, madam? Though the trial has progressed, only 5 witnesses out of 10 have been examined as of date. Bearing in mind the above circumstance and conscious as the court is of the provisions of section 37, we are of the view that it would be appropriate to grant bail to protect the personal liberty of the petitioner who faces an interminably delayed custodial period. Lordship has got it, madam. So, my lord, here also, my lord, that bar of section 37 was override because of the delayed custodial period, madam. And lastly, my lord, I have relied one of the judgments of this honorable court, my lord, page 18. Where Lordship was pleased to consider that aspect, my lord. Here in this case, my lord, page 19, it's the order starts from page 19. Here in this case, my lord, he was behind the bar for 2 years, 14 days, my lord. And only 3 witnesses could have been examined by the prosecution. And my lord, thereafter, Lordship discussed all the judgments of Honorable Supreme Court, and then Lordship at paragraph 11, considering, may I just read, my lord, this paragraph, my lord. Considering the entire facts and circumstances of the case, including the length of detention already undergone by the petitioner, and in the light of the views expressed by the Honorable Supreme Court regarding the period of incarceration, this court is the opinion that long period of incarceration may be one of the grounds for considering the bail prayer of the petitioner. And thereafter, Lordship, relying on the principles of Ravi Prakash, Lordship was pleased to grant bail to the petitioners. Mala, I am also similarly situated person, Mala. 2 years, 3 months in custody. And there is no chance that the trial will be culminated soon, Mala. And I undertake, Mala, to appear before each and every date as fixed by the trial court in the event Lordship considers my prayer, Mala.
The contraband was recovered in a conscious person of petitioner also. It was from his pockets also. 10 packets of color black contraband.
On that aspect, Lordship has earlier dealt with in our first bail application, my lord. Never argue that point, my lord, on merit, and that has been already been taken care of by this by the honorable court on wide order 4/3/2024. My only limited ground and is that, my lord, prolonged incarceration, which is one of the ground for considering bail, my lord, as these judgments, as well as the judgments of honorable of this court, my lord.
Narcotic MCB, the MCB versus Mohit Agarwal, Lordship. It was
Yes, repeat. Repeating. Such.
narcotics Lordship against versus Mohit Agarwal. That I
Acha, Mohit.
Agarwal. Case the judgment and the relevant portion I will.
My lord, with respect to the Mohit Agarwal judgment, Mohit Agarwal versus NCB, it was, my lord, only charge sheet was filed in that case, my lord, and thereafter the petitioner approached, and this aspect was not taken care of, her, because he was only, my lord, perhaps 6 or 7 months was there, if I am not wrong, and bail application was not. In that case, Mohit Agarwal, the Honorable Supreme Court said that my lord, delay in trial cannot be a ground. But these are the recent judgments, my lord, where these aspects were inordinate delay, my lord.
Order ইয়াতে দিব লাগিব ন। মোৰ দিগদাৰ হৈ যাব। Or this one, তাৰপিছত দি দিম আৰু।
Charge submitted.
Yes, submitted.
White CS number also 157/24, 157.
157.
Dated 16/9/24.
মই তেতিয়া আপোনাক Mr.
MS Mondal.
Mr. MS Mondal, the learned counsel for the petitioner. And also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. The case was fixed today for case diary, but it is submitted by Mr. Goswami. The case has already been charged by CS number 157, public 2024, dated 16/9/2024.
We will address the trial court lordship.
Yes. In view of the above, the petitioner is hereby directed to approach the learned trial court below with an appropriate application for bail, which may be considered in accordance with law. With the above observation, the will stand disposed. Okay.
29.
Let me finish. Whether this is a trial case lordship, what is there? Lordship, a victim and the informant has already been examined. Your lordship has already done this evidence. Lordship, page 23. If your lordship kindly come to the evidence of the reduced before the trial court lordship.
Page 23.
23 lordship. Your lordship may take the page 24, close part. In seat part also, she has also said that she has voluntarily, page
This is chief or course. 23 is the chief.
Chief.
Acha.
And 24 is the lordship pros in the middle lordship. I have stated to police that I was having love affairs, relationship with the accused from about 3 years prior to the date of occurrence. On the date of incident, I rang up the accused and asked him to come to so and so, and from there I went along with him in bus to Guwahati. And accused did not force me to go to go with him, but I voluntarily went with him. It is not a fact that I have not stated in my 164 CRPC statement that after I went with Khalilur Rahman, who is the petitioner to Guwahati, stay with him, then accused committed trap upon me. It is a fact that I have stated in my 164 CRPC statement that the accused is innocent and I went with the accused on my own will. My lord, 164 statement is your lordship will file case 28.
In this case, I have service not complete.
My lord, step we have already taken so as per the honorable court lordship, and that office looks perhaps he is not aware about the step lordship I have taken. My lord, on the very date lordship 23/10/2024 lordship. So the office of the PP lordship that was duly received. My lord,
Received.
Received by the
Received by the office of the PP lordship.
but not by the informant.
Well, as per this honorable court direction lordship, I have taken that step on that very day lordship. Because I am behind the bar for lordship 188 days. Out of 11 witnesses, 2 witnesses have already been examined. Lordship. Your lordship has
He has
already
taken
done.
steps, that is no doubt, madam. With the report has.
But whether this presence at this stage is necessary, lordship, considering the evidence of the lordship victim. And the lordship pays 28 is the 164.
No, it's okay. In the evidence, there is no such implication. But the question is, one notice has to go that much only the formality sake, otherwise whatever.
Yes, absolutely. Yes.
Now, you have taken steps that is submitted by Goswami, but it has not returned. Can you inquire the matter as to why will it fix a very short date here?
Very short date.
He will inquire the matter, we're fixing very 2-3 days with it.
Yeah.
Day after tomorrow, can it be possible? Day after tomorrow? Day after tomorrow?
Well,
Okay, day after tomorrow. 29, 29. List, we are listing it 29. Just he will make an inquiry. Just make an inquiry. He had already taken steps. And if it is there, then we'll pass the order.
Right.
29 we
Obliged.
list on 29 by click on it.
30.
This
My lord,
is
yeah. Just a copy of the notice was by.
Yes.
Obliged.
Wait, please, your lordship. And this case, my lord, yesterday lordship had heard the matter in length, my lord, that Aman Rava's case. my lord. CBL.
Hmm.
I am the manager of the Aman Rava. my lord. And I am behind the bars for 61 days.
Mr. Halloway is there, no? I
Lordship.
think,
My senior is Lex on port number 18.
port number 18.
Can you pass over the matter for timing?
Obviously, you have to pass over.
Otherwise, same, my lord.
But
I'm the manager, Aman Rava.
no, on that day, whatever, most probably it was the, Mr. Halloway was supposed to file an objection.
Yes, he has filed. my lord.
Already filed.
He had filed, my lord, and only the plea he has taken that I was a witness in signing the agreement. That much, my lord. 61 days.
Let him come, we'll see.
31.
In this case, lordship, I'm on interim bail, your lordship. Lordship will find the FIR in page 11, your lordship. I'm not the named FIR here. So basically, it's a civil dispute, your lordship, and there is a title suit and it's going on, your lordship.
And you were earlier, you were on interim.
Yes, lordship. And the named accused are all already in absolute bail, your lordship. The main accused, the named accused.
You are not the FIR named accused.
I'm not the FIR. Lordship, the similar accused persons orders you may, lordship may find in page numbers 43 onwards, your lordship. The Devnath Sharma.
Is it out of same FIR or other similar?
Same FIR. From same. Perhaps, lordship, let me clarify, your lordship. 147. Let me clarify, lordship. It's same FIR, lordship. Same FIR. Even in page number 47, lordship's order is also made absolute. In page 49 also, lordship. Arising of the same FIR. And I have taken instruction, lordship, on day to day, on whenever the IO is I called us, I am appearing before the IO. lordship. I think if that will reveal that. lordship.
So you are working there as under what strength?
Lordship, I'm just helping them, lordship, with lordship there with the process, your lordship. I'm not actually involved, lordship. I have not signed anywhere, lordship. There is no signature of mine in any of the documents.
Now, what is the role? What were you doing there with the agreement?
In that statement, I have given, your lordship.
He was an advocate's clerk.
Yes, lordship, advocacy.
Hello, he was witness to the Sendik matter.
Witness to this.
Witness to the Sendik.
And that has been admitted earlier. By them only, they have admitted that he was a witness to the cell
Yes,
deed
yes.
as identified by the learned advocate.
Advocate.
That is their plea earlier.
Yes.
So now what is the other issues there?
Well, other is one regarding the two person allowed bail by this honorable court, my lord. These are my regular bail. my lord. After my lord remaining there for considered
In
3 years,
custody.
my lord, they were released on bail. Now my lord, let's say may kindly pay with the FIR, my lord, page number 15.
50.
1.5.
Yes.
The vernacular of the FIR, my lord. I'm reading the middle portion, my lord.
Mm.
পিছত মই চাই দেখো যে মোৰ স্বামীৰ ছবিটো জালি কৰি ভুৱা দলিল বনাইছে মোৰ স্বামী যোৱা মানে দিছ ইজ ভেৰি ইম্পৰ্টেণ্ট মানে মোৰ স্বামী যোৱা 25/1/2018 তাৰিখে মৰিছে কিন্তু সেই দেৱনাথ শৰ্মাই মোৰ স্বামীৰ মৃত্যুৰ পিছত অৰ্থাৎ 23/3/2018 তাৰিখে দলিল বনাই আমাৰ মাটিটো আত্মসাৎ কৰিব বিচাৰিছে he already died when this deed was executed
Yes.
and this accused person they have identified him and they have witnessed the said this so as far as the materials are concerned sufficient materials collected by the investigating officer and although he was granted bail pursuant to that he has appeared but as far as the materials in the case diaries are concerned there are sufficient materials so he was granted bail in the motion stage
Otherwise, he is cooperating or
No,
no?
he has cooperated, his statement recorded. He has denied, but question is that, my lord, this sale deed was executed on commission, my lord. Commission means, my lord, the person, they does not come
Yes.
to the register office, they did it in somewhere else, in their house or in some other places. my lord. The person who have identified him and since the sale deed, my lord, they have, my lord, they have done it fraudulently, my lord. The person he has already died, how can he put his signature on it?
Lordship, in this case, actually, Mr. Kane Chaudhary is leading Lordship. Lordship, in that case, Lordship may hearing Lordship. Mr. Kane Chaudhary is leading Lordship. So
He is not available to.
it's not available today, Your Lordship. Lordship hearing.
Okay, then we retain the case there. Huh?
Any next week, any
Next week, candidate.
day, Lordship.
CD can be retained. At.
My lord, we can will it. For that may be fixed.
Otherwise, Lordship, in page 49, Lordship, he was, that is also an anticipatory bail, Lordship, he was apprehending against Lordship. One Mr. Shalendra Sharma.
The role is different for every person. Probably he is the witness. And now as Mr. Kusami is, Borwa has submitted that he put his signature for a person or identify the person who was not in existence in fact. So that is the prayer I will say to it.
Let the CDB retail Lordship and
Okay.
hearing on next day.
Okay. You are
DJ
Mr.
Das Lordship, actually, Mr. Kane Chaudhary is leading, so my name is not reflected here.
DJ does not otherwise.
On behalf of Mr. Kane Chaudhary.
Okay. Pardon, Mr. DJ Das. The council appearing on behalf of Mr. Ken Chaudhary, the senior advocate. Full stop. CD received, however, on the prayer made by Mr. Das. Matter is added on. Let it be fixed on fourth. Matter may be fixed on 4/12 so and so. Till then, CD be retained. We are retaining the CD.
Till then, interim may be continued. Lordship.
Interim was there.
Yes, Lord.
Interim be continued till next.
Much obliged, Lordship.
FIR at page number 12, my lord.
Yes, you are.
Please, Lordship, before my line up and start, Lordship, during the pending of the instant bail application, Lordship, the victim has been kidnapped. And
Oh.
he has not yet been recovered. Lordship.
Oh.
Who has been kidnapped? The victim. In this connection, we have already lost him, as I have before the police. But police is not acting in a state.
My lord, may please come to the FIR, my
But
lord.
this petitioner, the present case is registered under which section?
It is number one in the present bail application, as well as the present petitioner number.
The case is not registered with the rules.
Petitioner number 1 and 7 is also involved in kidnapping.
No, I'm not on that. Earlier the case is registered under 376 and 6 of the POXO.
My lord, 448, 354, 325, 506, 34. I think.
Oh.
My lord, may
So now you are alleging that the against a said kidnapping, the accused petitioner number 1.
It was petitioner number 1, 7, as well as main accused, because main accused is the petitioner before this honorable court.
Main accused?
My lord, these are the my lord, family members of the accused, my lord. This present petitioner, my lord, they are the family members of the accused.
All the petitioners are the family members of the main accused.
Main accused, my lord,
Main accused is not here.
not before us,
Acha, not before us. So they are the family members.
family member.
And as per you, the girl is already again kidnapped.
What?
So Against whom you have lost the FIR? Main accused and
Present petitioner number 1 and 7.
1 and
7.
7. Otherwise, Mr. Borua, we have received the case diary also.
My lord, there are the main allegation, my lord, commission of death, my lord. This is against the accused number 1, my lord, but he is not before us, my lord. Against the other accused person, my lord, what happened, my lord, the accused person, he was caught red-handed, my lord, while committing the offense, my lord. Then, my lord, somebody informed the family members of the accused, my lord. They came, my lord. These are the other family members, my lord, who were the petitioners in the bail application. They came and they have assaulted the, my lord, the informant and some other members, my lord, present. So, my lord, secondly, my lord, the medical report is not available, my lord.
Medical report of the victim.
Medical report of the, my lord, because there is a allegation of assault, my lord. So whether, my lord, this assault is sinful or in
Assault against the informant.
informant, my lord.
On the informant.
Informant by the accused person. Otherwise, my lord, the victim, he has implicated, my lord. 12347 in her 164, she has implicated. And other, my lord, the other eyewitness, my lord, who were present in the accident, my lord, they have implicated all the accused person, my lord, except the accused number 6, my lord, in the bail application.
No, but the question is that against them, the only section 323 or 324 is there, or other
My lord, POCSO will definitely not come, my lord. Rape and POCSO, it will not come.
may not come, but
May not
the other.
my lord, yes.
But now the allegation of kidnapping is also brought against 1 and 7 mainly.
So in this case, my lord, may I pray, my lord, to my lord, call for the update case there is. That will reveal, my lord, regarding the kidnapping of the guard and whether she has been recovered or not.
When you had lost the FIR?
12/10/2024.
12?
12/10/2024.
12/10. Achha.
Kidnapped on 10/10/2024. And the family of the petitioner are very influential person in the investigation because they have earlier issued warning for which informant has lodged a complaint before the superintendent of police Rashid. We have annexed it in our affidavit Rashid page 33 because they continue to pretend the
I may be allowed to submit, my lord. I may be allowed to present my case. My lord, please come to page number 12. May I read the FIR, my lord? Page number 12.
Yes.
It is humbly submitted there on 24/6/2024 at around 12:30 p.m. When my father and I returned home from the market, we witnessed the aforesaid accused number 1 was inside my house and attempting to rape my 17-year-old minor daughter. By forcefully covering her mouth. Upon seeing this, my father and I immediately captured the accused and rescued my daughter, thereby saving her dignity. The parents of the accused were informed about the aforementioned mentioned incident. Kindly note this line, my lord. The parents of the accused were informed about the aforementioned incident. Next page, my lord. After receiving the news, the relative of the accused illegally trespassed into my house. Mutually contradictory, my lord. First, they inform us, then they say they illegally trespass. I'm coming to the next point, my lord. Armed with dao, axe, stick, spear, etc., and started assaulting 4 of the family members, namely myself, my father, Sultan Ali Mozer, Sahanur Ali, son of Sultan, brutally injuring different parts of their bodies, causing bleeding, threw them to the ground before fleeing the scene, along with the accused number 1. So it is painful to state that for the past 1 year, the accused has proposed sexual intercourse with my minor daughter whenever we saw her, and also harassed her by calling her day and night on phone. Now, my lord, what happened? On this both the victim and the accused number 1, who is not before your lordship, they are in a romantic relationship. On this day, both of them were together at the residence of the informant. There is no doubt about it. When the informant and his father came from market, then they saw that the accused number 1 and the daughter of the informant, which is the victim, they were together. And the accused number 1 was tied with the veranda with some pole.
and they were informed. The family member were informed. The family member came, and because it is there in the know-how of the both the families that there is something going on between the victim and the accused number one, so they try to mutually settle it, saying that let us get them married after the girl turns 18. But because of that, there was some altercation between the family members, and then the accused number one was allowed to be taken away. Subsequently, they went and they filed this FIR, saying that this incident happened. Now, my lord, first they say that they were informed. Then they say illegally transfer. 448 doesn't come in here. There were, my lord, Arjina Khatun, Parveen Bibi. These are women, my lord. Safia Bibi. My lord, they cannot. 354 is not applied on them. POXO and 370, which were added later on, not initially. These are not applied on them. Now, my lord, my learned friend, first they went and so that I do not get bail. Arjina Khatun was pregnant, my lord. During this time, she was hiding from the police because there was an FIR against her. And during this time, she delivered a child. My lord, they first went and say, we are trying to intimidate them. That didn't help. Then they went and say, I kidnapped this, the victim was kidnapped. My lord, the truth is that they're living together now. The girl eloped with him. They are living together now. How will the police not take action if there is such a heinous crime like kidnapping? And this case is pending since ever, my lord. Because of something or other, we did not get bail till now. So it's a good story, I agree. But my lord, this is the reality, my lord. There's so many contradictory statements made even in the FIR, my lord. And then implicated us for what? POXO? For 376? For 354? My lord, the implication will not come on this point, my lord. Now, if my learned friend says that the updated CD, please call, but please, my lord, consider my interim.
Yes, any other submission?
My humble submission, my lord, regarding the kidnapping of the girl, my lord. If she is really, my lord, with the, my lord, accused number one, my lord, then my lord, it will reflect, my lord, in the case therein, my lord.
Very well, my lord.
Question is that, my lord, her age is, my lord, age is a question, my lord, because whether, my lord, she is now 18 plus or not, my lord. If she is below 18 years old, then it's an offense, my lord.
It's an offense only on accused number one, my lord, not on anyone else. He is there, he is not even in touch with us, my lord. They are locked. It's not a case of kidnapping, my lord.
So that will, my lord, reveal from the case therein, my lord. So may I pray, my lord, that after the case therein may come, my lord. After that, my lord, they are interim protocol, my lord.
My lord,
Maybe consider.
till this time, even my learned friend who is objecting, he says that everyone is not an accused here. So there is no bar to grant.
Yes, my lord. Regarding my lord, petitioner number 6, my lord. I definitely submit, my lord. There is no such sufficient materials, my lord. Against the petitioner number 6, my lord.
My lord, 2 and 3
regarding
also,
other,
my lord.
they are implicated.
My lord, 2 and 3, how can I be implicated in 376, POXO and 354? How can I be implicated in this action, my lord? Not possible, my lord. My entry may be considered, my lord, at this point of time. In the meantime, my
32. Heard Mr. E.W. Aman, Council for the Learned. Yes.
Implication of father that his daughter might have been sold out.
Might have been
Sold out by her.
sold out.
He's an educated person, he is running pillar to the post, but nobody is responding to the missing of daughter. So they have to explain the case because Indian family has been harassed by the APC.
my lord may come to page number 33, my lord. Their objection, my lord. Page number 33, the affidavit they have filed. This is the complaint that they have filed to the Superintendent of Police, Kokrajhar. Running from pillar to post is a very well drafted FIR, my lord. Complaint case, very well drafted FIR. Running from pillar to post. That is the only point I want to make. Complaining to the Superintendent of Police. First, I am threatening them, then I kidnap them, then I am selling them out. There is no end to this script, my lord.
The daughter of the infant has been kidnapped. The pay.
That may be reflected on
According.
updated CD may be called for. Updated CD may be called for, my lord. There are 3 female, my lord. One, she delivered while in hiding, my lord. We also have our own end of the story, my lord. There are 3 female, my lord, who are not there at home. Kindly see the date of the FIR, my lord. Kindly see the date of the FIR when it was filed. And since then, these family members cannot stay at home. And both of them, my lord, the accused number 1 and the victim, they eloped at the cost of our misery.
Heard Mr. A.W. Aman, and also heard Mr. R.J. Burwa, the learned counsel for the petitioner, and Mr. R. Islam, the counsel, the learned counsel appearing on behalf of the informant / respondent number 2. This is an application financial insurance. CD received, it's the same hardwood site. It is submitted by Mr. Aman, the learned counsel for the petitioner, that the accused number 1, accused number name, what is his name?
His name is Noor Haq Mondal, my lord. He is not before your lordship.
Yes,
His
yes.
name is
What is his name?
Noor Haq Mondal.
Accused number 1, Noor Haq Mondal. And the victim of this case are in a romantic relationship, and on the day of incident also they were together when the family members of the victim came, and as per the FIR also, it is seen that they were informed, the family members, by tying the accused number 1 in their house, but subsequently when they arrived, it was alleged that they have trespassed into the house of the accused, house of the informant, and assaulted the family members of the informant. He further submitted that all the accused petitioners are the family members of the accused number 1, and they are not at all involved in the alleged offense. The section 376, section 354, 376 IPC, and section 6 of the POCSO Act also cannot be attracted against the petitioner number 2, 3, and 6. 2, 3, and 6. And the other accused petitioners are only the family members of the accused number 1, and they are not connected in the alleged offense. Next paragraph. In this, accordingly, he paid for anticipated bail for all the petitioners, and it is submitted further that they will appear before the appear before the IO and will cooperate the investigation of this case. Mr. R.J. Burwa, the learned additional PP, submitted in this regard that the victim had implicated the accused petitioner number 1, 2, 3, 4, and 7.
Look, she has implicated 1, 2, 3, 4, and 7, my lord.
Yes, 1, 2, 3, 4, and 7.
And other, my lord, other witnesses, they have implicated, my lord, all the accused person, my lord, except the petitioner number 6.
And the other witnesses had implicated all the accused petitioner except the accused petitioner number 6. Further, Mr. Burwa submitted that there was an allegation of assault on the family members of the informant, but till that the medical report is not available in the case diary. Accordingly, he submitted that updated case diary may be called for. Full stop. Next paragraph. Mr. Islam, the learned counsel appearing. Mr. Islam, the learned counsel appearing for the respondent number 2, submitted in this regard that all the accused petitioners assaulted the family members of the victim and the victim, including the informant, and during the pendency of the present bail application. It is pending since when? Application?
My lord, this petition has been filed petition filed on 26th of July.
During the pendency of this so and so, the victim is already again kidnapped by the kidnapped and one FIR has already been instituted against the accused number 1, wherein and the accused accused number 1 and the petitioner number 1 and 7 are also implicated in the said FIR. He further submitted that all the accused petitioners are very influential person and they threaten they are still threatening the informant and his family members, for which the informant had to move from pillar to post for the justice poster. Accordingly, he raised objection and submitted that the bail application should not be considered at this stage. Next paragraph. Considering this submission made by the learning council for their both sides and the materials on the record, it is seen that the allegation that section 376/6 of the POX 376 IPC and 6 of the POXO Act admittedly do not attract against the present accused petitioners. And in the same time, it is also seen that the petition is pending since month of July and hence considering all the aspects of the case vis-a-vis the FIR lodged with the allegation of kidnapping of the victim girl, I find that except the accused petition number 1 and 7, the accused 1 and 7, the other petitions, that is the petition number 2, 3, 4, 5, and 6, may be granted with interim protection till the receipt of the updated case diary.
Well, 2 and 3 also may be considered, my lord.
Yes, 2, 3 I have considered.
My lord.
2, 3, 4, 5, and 6.
My lord,
considered.
my lord.
Till the so and so interim corridor. 20,000 with 1 COT corridor till the receipt of the updated case diary. Can you tell us the number of the order hearing? Your case number?
Which have not been registered.
Not yet registered.
Not yet registered, because we have submitted before the police station, and police says that it will be added along with the original FIR.
Is to be added.
Along with the original FIR.
So have you made any application before the OC or the investigating
Yes.
officer regarding your allegation of kidnapping and all that girl is still missing?
On 12/10, we have lost the
No. 12/10, you have lost the
information.
information.
FIR.
That's what I'm saying. FIR is lost,
Registered. FIR has been
Not
lost,
registered.
not registered.
not yet registered.
Not yet registered.
And if you want to, I was thinking that the CD of the other case may also be called for, but if it is not registered,
Typical, my lord. If it is not. Let this, my lord, after the city may be called from, my lord. There may be, my lord, some.
some
report of the
materials may
IO.
be there.
Question is that, my lord, is assuming, my lord, she again eloped. And she is, my lord, married with the, my lord, accused number 1 in the FIR, my lord. And they have solemnized their marriage as per law, my lord. That, my lord, there is no problem. Otherwise, if the girl is really missing, my lord, then it will be difficult, my lord.
Yes, if girl is missing, then it will be difficult definitely.
Whereabout it's not known, my lord. It will be difficult.
And if she has submitted that if it is, she has already been sold, then it may be a problem.
Yes.
They will be remain on interim till next date of listing of our updated case diary. In the meantime, if any materials had been collected by the IO in connection with this case regarding the kidnapping and all, then it will come.
You can also file an application.
Otherwise, 164 statement of the victim earlier is not recorded.
It is recorded, man. It is recorded.
He or she has already implicated.
She has
Oh, that
implicated.
means, yes,
He has
implicated.
implicated. Regarding, my lord, the non-registering of the FIR, my lord, you can approach, my lord, non-chief judicial magistrate, my lord, for registering a case.
Oh, yes, you can. You can file a petition before this is their condition. FIR is not being reception and or definitely there is a police accountability section also.
My lord, does not fix any date, my lord.
Like, tell us date, any date you can tell.
This will be madam on 30th of December, madam, 1-3.
1-3. 13th of December. It's within 7 days, they will asked to appear before the IO.
I'm
You
grateful.
appear before the IO,
I'm grateful, madam.
and for 1 and 7 to reject kora ase. Don't give any rejection order. We are pressing on.
I'm grateful, madam.
33.
Complete lordship. 482 application lordship. You know, in this case, my lord, the accused person, they were granted interim, my lord. But their statement is not in the case there. So may I pray, my lord, since he is already.
What is your instruction? They have appeared?
They have appeared here. We have to forward update case there, my lord.
Your case diary is updated till when?
This, my lord, to May, my lord.
May. Also. Because interim order was on 9/9 in fact.
My lord.
Heard Mr. R. Chitri, the learned counsel for the petitioner. And also heard Mr. R.J. Borwa, the learned additional PP, so and so. It is submitted by Mr. Borwa that CD received, but it is not updated one, and the last entry is made only up to May 2024. And he further submitted that the statement and hence the statement of the petitioner is also not available in the case record. Later reminder will be issued directing the investigating officer to submit the updated case diary along with the statement of the petitioners if already recorded. List accordingly when it can be listed.
No, 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 17, 12, 7.
No, don't keep January.
January.
Make it January.
After June.
No, after view, prior to view, you can.
7.
7/1.
Obliged.
Till then, interim be continued.
Yeah, please, your lordship. The FI is at page 9, lordship.
In which one we have to? Which one we have to see? No, in 34 or 35?
34, lordship.
34. FI is at page 9.
Page 9.
It is PP is there. Hello is appearing here.
Yeah, lordship, it is transferred to.
Oh, acha. Okay. So you are saying page 13,
Page 9, lordship.
page 9.
Page 9.
Yes.
Allegation in the FIR is not against me, lordship. It is against Ranjit Kakoti, lordship.
Lordship, if I'm not wrong, Lordship, this matter has been dealt with by Justice Palashin of the FI.
Okay then. Other matters they have been cases. Now dealt with is another one aspect and the whether any bill disposed of. Okay, we'll let us see.
Ranjit Kakoti.
Ranjit Kakoti has been main accused, has been given bail, lordship.
Yes, it is disposed by Justice Malastin only. Your CD is available or?
Yes, it is available.
CD is available. Can it be retained then?
Yes, it can be written. Lordship.
Can be retained.
Lordship may take up the matter, lordship.
Huh?
Lordship may take up the matter, lordship.
No. Nowadays it can't be. Heard Mr. S.J. Sharma, the counsel for the petition. Also heard Mr. Hello, the understanding counsel for the respondent. CD received.
May I pray, Lordship, CD as because it belongs to nearest only Guwahati. Can this again bring any another date, Lordship?
But I don't know whether are you on any interim protection is there?
No, interim protection.
In that case,
Not behind bar.
behind the bar?
No, yeah,
Oh, it's a sorry.
heavy matter.
Yes,
24/9, lordship, it has been lingering.
pending.
Yeah, lingering. Yes. Maybe it may be fixed on 27, 30, lordship, because
30, 30.
30, lordship.
30 is holiday, I think. Saturday. Hello, please tell us, or otherwise 2, 3, 4, 5, we can fix it.
Lordship, 29. Maybe on 29, lordship, because it is lingering from a long time, lordship. Several dates have been passed.
No, CD is already there. We are
Yes,
not going to.
CD, whenever matter list have been being a CD, it's not like that we are not, every day we are producing the CD.
Mhm.
Likewise, also the investigation is not had got hampered.
Hampered, yes.
That is the difficulty.
We listed on
Make it, let it
29,
be on second, third, or
Let it be on the fourth lordship, fourth lordship. Let it-
4th of, okay.
Fourth of December. lordship.
Please vote the matters before appropriate bench on 4th of December. Till then, CDB retained.
Timing 30.
lordship, I have a prayer, lordship. Lordship, in the respondent, CBI council name may be shown.
Yes.
Yes.
That is one.
Further, the registry is also directed to reflect the name of standing council CBA
Special.
on the special PP CBA on the next database. Now here in this case, Mr. Haloi, you have already filed your objection.
Lordship.
Actually, I'm preoccupied with some other works, in fact.
Lordship.
So today it may not be heard. Can it be retained till tomorrow?
Tomorrow, lordship, already this is exhausted, lordship.
Huh?
List mine, I mean to say that list.
Your list is.
Okay. Let it be on lordship then.
Otherwise, Friday then. Friday can be.
Friday, yes. It will Friday.
Friday. Yes, anything you're submitting?
Otherwise, my lord, I have already crossed my lord the mandatory period, my lord, 60 days.
For him, it is 60 days.
Yesterday's argument of senior. advocate
More or less same.
Borasam and his argument will be same. And
Because
I think after the same FIR, accusers, I mean to say accusers are different, but the act attributed by the accuser says. It will also goes to the civilian statement of witnesses.
but the affidavit filed by them, my lord, there is only one line, my lord, which accused me, my lord, that says, my lord, the accused petitioner Shankar Shah stood as a witness and signed all such agreements.
Yes.
Whether the 316, my lord, the meeting of mind is there, my lord. Only I stood as a witness. That much, my lord.
These 2 days of witness, if your lordship see the CD also, statement of I mean, the witness.
And my lord, moreover, my lord,
Induce the people also.
and moreover, my lord, they are stating
To take money.
they are stating, my lord, 2 companies, my lord. And in fact, I am not the manager of that 2 companies. I am a manager of a company which belongs to him, my lord. But that 2 companies are not there, my lord.
In fact, lordship, if your lordship see the statement of witnesses and the agreement which has been sworn, lordship, is this accused who induced the people to believe that if you give this much of money, you'll get benefit, lordship. Lordship, CD is there, lordship. May I have a look into the statement of witnesses to reveal the fact that is under the instruction of this accused, people are investing money. That is.
Anyway, okay. So Friday we are listing it.
Lordship.
Just on Friday, till retained it gets ready till next set of listing.
Lordship, retail its Guwahati branch, I'll bring it again on Friday.
Okay,
Because we have no safe custody here.
okay, you can bring it.
Yes,
Retained means retained by the PP.
we have not.
He will retain, my lord.
cannot-
Because they don't have an office, my lord, so PP will retain.
We will
Send
not
it
mention, you just
I
approve.
will bring lordship.
And will produce the CD on the next date of listing for it, retain no reply. PP is to produce the CD on the next date of listing, that's 29,
29, my lord.
11. Okay.
Ali.
I am of them.
37.
Actually, the case of child marriage, my lord.
Hmm.
Apparent case 12, your lordship. The petitioner number one and the victim, they are passing their life, conjugal life peacefully, your lordship. FIR at page 12, your lordship.
No, you have appeared for the response. FIR is
Got
that page?
Page 12.
Ah, yes.
In the FIR, it is stated that the victim was as at about 17 years.
Hmm.
My lord, in fact, the petitioner number one and the victim, they eloped from their respective houses and disregarding their guardians, they solemnized their marriage, your lordship. And presently they are passing their conjugal life. And in last month on 25/10/24, one baby is born, your lordship. So then may kindly be granted, your lordship. The response number two is the father of the victim. The father of the victim was also arrested, my lord.
Yes, he is for child marriage.
Yes, your lord.
That's why he is arrested.
My lord. That sheet submitted showing them to be absconded.
Is it charge sheeted case?
My lord. So bail may kindly be granted and we will face the trial.
Showing both the accused petitioner and founder.
My lord.
Yes, who submitted the submission.
And my learned friend is for the informant.
Yes, what is the submission? You are for the informant. Father of the? Then who is number two? Father of the accused.
Father of the victim. No.
No, do we do
wait.
both are fathers?
No, no. Who is the father of the petitioner number one?
Oh,
Petition number two is the father of petitioner number one.
Huh?
Son and
Petitioner
father.
number?
Son and father.
And number, respond number two is the,
Petitioner two is the father of victim.
and who is the informant?
Informant is someone else, your lordship.
Oh, that means you have not made party.
Guardian is made party. Guardian.
You have suppressed that fact.
No, my lord.
And
Yes, what?
there is a office note also 1911.
Hmm.
Which says that steps not taken in action number two. That's not
No.
whether he is,
He is the respond number two. You are,
Hello.
who are you?
he is not responsible.
What is your name?
But he is the respond number two.
Abdul Barik Sheikh.
Yes. And any manner to the either to the victim or to the manner that can be
Guardian,
other side.
yes, that can be. That's right.
This person was there.
So what is the stage of the case at present?
At the initial stage of appearance, your lordship.
The order you have annexed?
My lord. At
Where
page
is the order?
27.
28.
Face the trial, your lordship. But they are apprehending arrest, your lordship.
Till now, only summonses are issued.
My lord.
You have any instruction on 2310? Is there any order? 2310,
At same stage. Someone else.
we have not annexed here. Do you have the order? Only summon issued or any NBW or BWA
No,
issued?
no NBW is issued, my lord. Only someone issued.
So Mr. A. Rahman,
My lord.
heard Mr. A. Rahman, the learned counsel for the petitioner. and also heard Mr. MP Kuswami, the learned additional PP, appearing on behalf of state respondent, and Mr. M. Mondal, the learned counsel, appearing on behalf of the respondent number 2 / the father of the victim. This is an application under section 482 BNSS for granting P-arrest bill to the accused petitioner in connection with special case number 304 2023, arising out of Gauripur PS case number 94 of 2023 under section 376 IPC, read with section 9 PCMA Act, PCMA 2006, read with section 4 of the POXO Act, and read with section 75 JJ Act. CD received, they will receive, heard both sides. CD also same thing is there.
The scan copy, my fault.
Or
Yeah, those
scan
are
copy
taken.
of the charge.
But the scan copy, but take because the steps, it has been stated in the office, not the steps not taken. That is why what.
Scan copy is received, right?
Scan copy is received, madam. The stage of the case.
Mr. Ravan, the learned counsel for the petition submitted in this regard that as per the FIR, the victim was 17 years of age at the time of her marriage, though she was more than 18 years at the time of her marriage. The marriage was solemnized between the petitioner number 1 and the victim in presence of the family members of both the parties.
In absence,
In absence of,
Madam.
why in absence?
they eloped from the
Oh,
house.
আচ্ছা আচ্ছা no no লিখক তেতিয়াহ'লে কি লিখিছে আগৰখিনি no সেইটো কাটি দিয়ক লাইনটো কাটি দিয়ক but submitted that both the victim and the accused petitioner number 1 is in love relationship and they eloped and got married and happily residing as a husband and wife. On 25/10/2024, one child was also born out of their wedlock. However, the accused petitioner number 1 and his father were not aware about any institution of any case before the court and before the court and before the court, and nor police search for them during the investigation of this case. However, it has come to the notice of the both the petitioners that the charge sheet has already been filed, showing both the accused petitioners are absconded, showing both the accused petitioners as an absconder, and the summonses are already issued against them. However, there is apprehension of arrest in connection with this case, and accordingly, both the petitioners have appeared before this court with a prayer for anticipatory bail. First off, but they are ready and willing to appear before the London trial court below and to contest the case accordingly if they are given a chance to appear before the given if they are if some interim protection is given to both the accused petitioners. Next paragraph, Mr. Gusami, the learned additional PP submitted in this regard that both the accused petitioners were shown absconder in the charge sheet. And accused victim was a minor at the relevant time of incident full stop. However, he submitted that the petitioners may be directed to appear before the learned trial court below with an application for bail without any kind of interim protection. Next paragraph. Mr. Mondal, the learned counsel appearing for the respondent number 2 / the father of the victim, submitted that both the victim and the accused petitioner number 1 are residing happily as husband and wife, and hence he has no objection if Both the accused petitioners are granted with the privilege of bail. Stop. Next para, considering the submission made by the London Council for both sides, and have also perused the scanned copy of the record received. From record, it is seen that
Or
the
appearance.
Huh?
Appearance.
Oh.
The next day.
case is still at the stage of appearance. And the learned trial court, learned special judge, learned special judge POCSO had already issued this summons against both the petitioners. On last date of last occasion, that is on last date, that is on 23/10/2024. One petition was filed on behalf of the accused petitioners, which was allowed, fixing the next date on 22/01/2025. First, considering the materials available in the case record, public case diary, and also considering the submission made by the Learned Council for both sides. Both the petitioners are hereby directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law. However, till their appearance till next date of listing, the accused petitioners may be protected and no coercive action shall be taken against both the accused petitioners. With the above observation, because NPW is not yet issued, so we are listening that no coercive actions can be. Otherwise, only summons are issued, and that too your petition was allowed, in fact. So appear before the learned trial court with the observation.
They may be sent.
Till we have given you interim protection
Right.
till your appearance, because regular bail will be there now. But you have to go on regular bail also.
Right.
So till next date of listing, you are on interim protection. No coercive action shall be taken
It
against
will
you.
appear within 7 days.
Well, I'm just leaving you liberty on or before. You are getting more than 7
Right.
days.
But
Okay.
Before of the supplementary list.
$50. Yes.
Thank you so much. My lord, this is a pre-release bail application, my lord. In this case, my lord, petitioner was shown as an absconder. Charge sheet has been filed. My lord, kindly peruse page number 31, annexus 6, my lord. Yeah, in this case, my lord, a scan copy was called for and that has been received, my lord. Page
This
6.
is the summon.
Summon. After receiving this summon, my lord, the petitioner came to know that the case has been pending against him before the special judge POCSO, Nagaon, my lord. Then thereafter, my lord, the petitioner applied for the certified copies of the FIR along with the records. And thereafter, he came to know that an FIR was lost against him, my lord, by the informant. My lord, kindly come to page 16, my lord, 16. This is a copy of FIR, my lord. My lord, this FIR was lost on, my lord, 26/9/2023 in above this date. And this was lost before the, my lord, Superintendent of Police, Nagaon. And after receiving this complaint petition, my lord, the same was forwarded to the officer in charge, my lord, and accordingly the case has been registered, my lord. Now, my lord, kindly come, may I read the contents of the FIR, my lord. এজাহাৰ কৰি সন্মানপূৰ্বক বিনীত নিবেদন এই যে শৰীফা বেগম মোৰ নাবালিকা ছোৱালী, তাইৰ জন্ম 3/1/2007 আৰু সেই মৰ্মে তাইৰ বয়স 16 বছৰ 9 মাহ। শৰীফা বেগম জন্মগতভাৱে কলা আৰু ববা আৰু বেঙী প্ৰকৃতিৰ। আসামী আমাৰ ওচৰৰ চুবুৰীয়া সেই মৰ্মে হিচাপে আমাৰ ঘৰত অহা যোৱা কৰে
মোৰ পৰিবাৰৰ মৃত্যু হৈছে আৰু অন্য মানুহ নাই সেয়ে মোৰ অনুপস্থিতিত মোৰ বেঙী ছোৱালীজনীৰ লগত যৌন সম্পৰ্ক স্থাপন কৰে আৰু যাৰ ফলত তাই গৰ্ভৱতী হয় যোৱা ইংৰাজী 17 মাইলত যোৱা ইংৰাজী 10/9/2023 তাৰিখে সন্ধিয়া 6:30 মান বজাত আসামে পলুৱাই লৈ যায় আৰু এসপ্তাহমান পিছত তাইক উদ্ধাৰ কৰিব পাৰো এই বিষয়ে থানাত জনাইছিলো উদ্ধাৰ কৰাৰ পিছত তাই শাৰীৰিকভাৱে বহুত দুৰ্বল দেখি তাইক সোধ-পোছ কৰাত জানিব পাৰো যে তাই গৰ্ভপাত কৰাইছে মই চকুৰে কম দেখা পাওঁ আৰু শাৰীৰিক অসুস্থতাৰ বাবে এই গোচৰ দিয়াত পলম হ'ল Now my lord kindly come to page number my lord 14 after receive this information my lord and
40 or 4?
14 my lord.
Oh, 1.
Here, my lord, kindly note that GD entry number, general diary reference number 03, date and time, my lord, on 17/10/2023. My lord, this is the second affair, my lord. Now, my lord, kindly come to page number 21. This is medical reports. The allegation in the affair that the victim was eloped with the petitioner on 10/9/2023 and after 1 week she was recovered. The allegation is that, my lord. Now, my lord, kindly page 21. Here, lordship will find this is medical report, Sharifa Begum. On 14/9/2023 at 4 p.m. So and so, Jumana Bora, so and so, height, Lupohia PS ZD entry number 213, dated 11/9/2023. The allegation in the affair that on 10/9/2023, the petitioner eloped the victim guard, and after 1 week, she was recovered. But the medical report shows that, my lord, the ZD entry is different, and FIR was lost against this, my lord, incident. But ZD entry was on 213 on 11/9/2023, my lord, on the next day. And on the basis of this ZD entry and medical report was medically examined the victim. And my lord, kindly see the opinion part. There is no evidence of recent forceful sexual intercourse. Her age, according to the repeat case, my lord, it is between 15 to 17 years. Now, my lord, in the FIR, my lord, the allegation is that, and facts are there, that the daughter of the informant, she is a dam and diff, and I have annexed the school certificate of the victim girl, my lord. From the bare perusal of the record, my lord, kindly come to page number 24. That is the reading certificate of the victim girl. My lord, this page number 24, my lord, certified Miss Sharifa Begum, and this certificate was issued by Headmaster Tarabat Girls High School and Noga. Well, from the record, it shows that, my lord, this is not a dam and diff school, my lord. And the facts is which has been narrated in the second FIR, they are afterthought and false and fabricated, my lord. And the medical documents, my lord, also not supported the whatever the statement or allegation narrated in the FIR against the present petitioner, my lord. Now, my lord, the petitioner has received the summons showing him an absconder, and my lord, kindly come to annexure 5, my lord, that is the charge sheet, my lord. Page number 30, my lord, the relevant portion. Regarding, my lord, that dam and diff portion, my lord, তদন্ত কালত ঘটনাস্থলী পৰিদৰ্শন কৰি মানচিত্ৰ অংকন গুচৰি আৰু সাক্ষী জবানবন্দী লোৱা হয় ভিক্টিম শৰীফা বেগমৰ বয়সৰ প্ৰমাণপত্ৰ জব্দ কৰি মহামান্য আদালতৰ দৃষ্টিগোচৰ কৰোৱা হয় ভিক্টিমক থানা আৰু মহামান্য আদালত জবানবন্দী লিপিবদ্ধ কৰা হয় জবানবন্দী লিপিবদ্ধ কৰাৰ পাছত চিভিল হস্পিটেল সাক্ষ্য পৰীক্ষা কৰাই প্ৰতিবেদন সংগ্ৰহ কৰা হয় ভিক্টিমৰ জবানবন্দী তাইক আসামীজনে ধৰ্ষণ গৰ্ভৱতী কৰে আৰু পৰৱৰ্তী সময়ত তাইক টেবলেট হৈ গৰ্ভপাত কৰে বুলি জনাই যদিও স্বাস্থ্য পৰীক্ষাত প্ৰতিবেদন সংগ্ৰহ কৰি তাইক গৰ্ভপাত কৰাৰ কোনো তথ্য পোৱা নাযায় Now, my lord, the section has been registered under section 363 376 and section 4 of the POCSO Act. 376, my lord, the facts narrated in the FIR, the victim eloped on 10/9 and she was recovered on after 1 week. But from the medical report, it shows that the victim is recovered on the very next day. So there is a doubt, my lord, whether she was kidnapped or not. And regarding, my lord, section 376, my lord, medical report shows that, my lord, no such sexual intercourse to the victim, my lord. And section 4 does not apply to the present petitioner, my lord. The definition of section 4, my lord, punishment is given that aggravated sexual assault, penetrative sexual assault. That the definition is given under section 3, my lord. The allegation narrated in the FIR, the ingredients which to be in section 3, these are not in the present FIR, my lord. So my submission before a lordship, my
How
lord,
can you say if there is, suppose it is no forceful intercourse is there,
My lord.
that force is not applied.
My lord.
But how can you say there is no penetrative sexual assault on her?
my lord, the definition, what are the ingredients, my lord?
Yes, incidence is there.
Ingredients, but in the FIR, my lord, that the allegation is not against that support the ingredients, my lord. Section 3, my lord. Now, my lord, as the accusers issued the summon, my lord. So the object of the bail is to, my lord, to secure the appearance of the accused person to ensure to put a trial court, my lord. So I am ready to appear, my lord, to as an earlier date, my lord, I have filed petition before the learned trial court below, my lord. For taking adjournment, my lord, as I have preferred this bail application before this honorable court, my lord. So some protection may be given, my lord. I will appear before the court below, my lord.
Yes, Kusan.
You can see is a defendant, my lord. I have 164 is not there, but it should have been there, my lord. Perhaps it is not in the record. And the other thing, my lord, medical is there, my lord.
Here you
Even
have
parts I have flag mark, my lord, what is there in that. At 164 I could not found.
164 you have not found,
No.
but Sarsil, why it has been written then?
My lord, specifically written. Bosoria or victim or Samagondi for attack as a talk on for
This is the admission register in deaf and dumb school or what? You have flag mark here one. Oh, this is the CS. Oh, sorry, sorry.
One is Sarsi, one other is birth certificate. And one is medical.
Now, one thing is there that girl is reading in a normal school. It's not that it is a specific, I mean, special school or for special child. So reading in a school, a normal school, there are some reasonable doubt arises in regards to whether the girl is completely deaf and dumb. She may be a bit of idiotic person or like that, but complete deaf and dumb is not there.
Yeah, the 164 there is a process for taking that statement, my lord. So if it is there, then we could have, my lord, seen whether CS voluntarily given 164 or she has been interpreted, that we cannot say.
164 is not available.
Then only we can, my lord, very constructively say, my lord, that
It is as per statement of the, I mean, in the charge sheet only, that her statement is recorded. That is the problem. Yes, he is appearing for respondent.
I'm appearing for the phone. It is certificate case here, Lord. If they want to appear, then I have nothing to say anything about her appearance. Perhaps it will be the mode of expedited trial here. If you want to appear, then
What's your address? Let me appear before. Heard Mr. DJ Halwi, the learned counsel for the petitioner, and also heard Mr. MP Goswami, the learned additional PP, appearing on behalf of state respondent, and Mr. AM Khan, the learned counsel for the respondent number 2. This is an application so and so. Public review 438 insolvency. Scanned copy of the case record has been received, produced the same hardboard side. It is submitted by Mr. Halo that the present accused petitioner is innocent and he is no way involved in the alleged offense. Further, from the full certificate obtained by the petitioner, as well as from the statement made in the charge sheet, it reveals that the victim was not a deaf and dumb girl, as stated in the FIR. More so, there are contradictory dates in the registration of the FIR, a recording of the recording now, registering of FIR in regards to GD entry vis-a-vis the medical report collected by the IO poster. Though it has been alleged that the victim was recovered after 1 year of her 1 year after the one week after the this said incident, but the medical reports speaks otherwise, and wherein it is seen that the victim was examined only on the next day of the incident, wherein doctor did not find any sign of forceful intercourse with the girl. The poster, he further submitted that the accused petitioner was not aware about the pendency of this case. Only after receipt of the summon, he applied for the certified copy of the FIR and other relevant documents, and then only it has come into the knowledge that the case was charged against him, showing him as an absconder. However, he is ready and willing to appear before the learned trial court below and to contest the case by appearing each and every day to be fixed by the learned trial court below, if some interim protection is given to him. Next para, Mr. Goswami, the learned additional PP submitted in this regard that though the birth certificate and the medical documents, etc., were collected by the IO, but there is no statement of the victim is available in the scanned copy of the record, as though it is stated in the charge sheet that her statement was recorded under section 164 CRPC. So without any
It is not clear whether so many lordship may not observe. Only lordship may not observe that in the search sheet as per the statement of the victim. That is, it is not stated whether it is 161 or 164. Nothing is
statement to 164 to শব্দটো কাটি দিবা. Okay,
only
statement.
the statement and the other part 164 because
But 161 is also not available.
161
Here,
CD part will be there.
164 obviously is not available. One. However, he submitted that the victim may be, the accused petitioner may be directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law. Next para, Mr. Khan, the learned counsel, appearing for the respondent number 2, submitted in this regard that he has no objection if the accused petitioner is directed to appear before the trial court below, as on his appearance only there may be a speedy trial in this regard, and thus he raised no objection. Next para, considering the entire submission made by the learned counsel for both sides, veterans in the case diary vis-a-vis the record, and the other aspects of the case, I find that one chance may be given to the present accused petitioner to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law. However, till within 10 days you can be able, will appear within 10 days করে দিব. Until then, there may be the petitioner may be the interim protection may be able কেনেকে দিব দি দিব মুঠতে হেৰি নকৰিব. It will be আপোনাৰ 10 days থাকিব, and till 10 days no corrosive, because NBW is not here. No corrosive action shall be taken against the accused petitioner.
Statements. Okay.
Statement is not there. 161 is also not there.
Because entire CD is not there.
That means she might be a defendant, but other way, on the other hand, she is a school student. Anyway, he will appear within 10 days with an appropriate application for bail. The someone has already received by him.
One observation, my lord, this shall not be precedent because lawsuit is my lord allowing the ex-mother, my lord, they are allowing to appear. Just case circumstances of the case, my lord.
Yes, obviously, this is the peculiar circumstances
Yes,
only.
this shall not be precedent because otherwise, yeah, other cases.
Line এটা লিখি দিব, this shall may not be a precedent.
In the earlier case also.
Yes, and
Item 18 for admission.
So earlier court's order, my lord, 31/7/2024, my lord. A scanned copy of the, my lord, Lokhipu PSK was called for. As per office note, my lord, the scanned copy is not received, my lord. Last office note dated, my lord, in the month of September, my lord, a scanned copy not received yet, my lord.
it is has to come from which court?
My lord, Lokhipur PS, my lord,
Hubli.
no, my lord, Silchar. Kasar, my
Silchar,
lord, Kasar, my
Silchar.
lord.
Acha. And what about the respondent number 2?
Respondent number 2 already appeared, my lord. They have filed the
Already appeared.
affidavit in opposition. We have already filed the reply, my lord. The case is ready for, my lord.
Oh,
my lord.
only
But-
to receive the.
Yeah, LCR, my lord. Maybe, my lord,
We are issuing reminder this time.
remainder, my lord, and maybe fixed for, my lord, December, first week of December, my lord. There is some urgency, my lord. First week of December, my lord. Maybe fixed, my lord.
You are Mr.
T Sheikh, my lord.
T. Sheikh, the learned counsel for the petitioner. And also heard Mr. MP Kusami, the learned additional PP, appearing on behalf of state respondent. It is submitted by Mr. Sheikh that the notice is already served on the respondent number 2, and accordingly, she has already been represented. The petition respondent number 2 has already been represented, duly represented by the learned counsel. However, from the office note, it reveals that the scanned copy of the record is not yet received by the registry. Post of expera. The registry is accordingly directed to issue reminder and to take necessary steps in procuring the case record on or before the next date of listing. List the matter accordingly. It will after 1 week, December 1st week, it may not reach.
Then, my lord, second week, my lord.
List the matter accordingly on the 2nd week of December.
But-
As on the date.
Specific date,
Specific date we cannot be.
my lord. Oh, last, my lord.
19. Lordship, in this case, we have filed one application before the learned trial court for recalling for re-cross-examination, PW1, PW10 and CW1, Lordship. That was rejected. Page 28, Lordship. That petition was rejected and thereafter notice.
Just a second, the scan copy you have received already?
Yes, Lordship.
It has come.
Yes.
Otherwise, not
25.
in the last occasion, they were ordered, to, that's why.
Your Worship, as per office note 2511, scanned copy of evidence of witnesses in connection with so and so is
Receipt.
received from
Oh,
the special
okay.
judge. Page 28, Worship.
So you filed a petition for cross-examining or what?
Lordship, re-cross-examination.
Recross.
Already cross-examination was over. Lordship. Page 24, annexure 6 is the petition. Lordship. Petition under section 340.
Acha, Goswami, Mr. One amicus was appointed
D.
here. no?
Gogoi.
Huh?
D. Gogoi, Lordship.
D. Gogoi.
His name is reflected in the office.
Is he appearing?
On last occasion, he was there.
He appeared, huh?
Dixie,
Okay.
Dixie.
Dixit, Jyotika also.
Somebody to know.
Lordship may take after some time, I'll call.
After some time, will not time, no time. This
Yes,
is your last case. Last I'm hearing this one, otherwise. You start submitting, I'll note them.
Lordship.
In the meantime, if it can be, that can be informed. Okay, so what is your petition is that page?
Lordship, annexure 6, page 24, Lordship. Petition under section 348, 311 of Lordship CRPC. BNSS.
Hmm.
That the above noted case is fixed today for statement of defense.
Hmm.
He has come, Lordship.
It is Sumayali.
Yes.
My lord, I am the amicus basically.
No, she is submitting, yes, any.
Yes, yes. And the amicus appointed by. Oh, আপনি হেল্প করেন
That in the above noted case, since after completion of the examination and cross-examination of the 10 numbers of PWs, including of the IO, that is the PW number 10. This honorable court on 10/5/24 closed the prosecution evidence and posted the case for examination of the accused under section 313 of the CRPC by fixing on 13/5/2024 for statement of defense. That on 13/5/2024, this honorable court has been posted the case on 16/5/24 for CW, and accordingly on 31/5/24, Sporshika Garg JMFC North Salmara
Section is a general section which applies to all proceedings, inquiries, and trials under the code and empowers the magistrate to issue summons to any witness at any stage of such proceedings, trial, or inquiry. In section 311, the significant expression that occurs is at any stage of any inquiry or trial or other proceeding under this code. It is, however, to be borne in mind that whereas the section confers a very wide power on the court on summoning witnesses, the discretion conferred is to be exercised judiciously. As the wider the power, the greater is the necessity for application of judicial might. As indicated above, the section is wholly discretionary. The second part of it imposes upon the magistrate an obligation. It is that the court shall summon and examine all persons whose evidence appears to be essential to the just decision of the case. It is cardinal rule in the law of evidence that the best available evidence should be brought before the court. Section 60, 64, and 91 of the Evidence Act 1872 are based on this rule. The court is not empowered under the provisions of the code to compel either of the prosecution or the defense to examine any particular witness or witnesses on their side. This must be left to the parties. But in weighing the evidence, the court can take note of the fact that the best available evidence has not been given and can draw an adverse inference. The court will often have to depend on intercepted allegations made by the parties or on inconclusive inference from facts elicited in the evidence. In such cases, the court has to act under the second part of the section. Sometimes the examination of witnesses as directed by the court may result in what is thought to be filling of loopholes. This is purely a subsidiary factor and cannot be taken into account. Whether the new evidence is essential or not must, of course, depend on the facts of each case and has to be determined by the presiding judge. So, Lordship, as on the basis of 311 CRPC, it is permissible at any stage, even at the fag end of the trial. And now this trial, Lordship, only at the statement of defense. My humble prayer before your Lordship, a chance may be given to re-cross-examine those two witnesses. One more judgment I have cited, Lordship, that is already there. Para 11 and 12 I have marked on similar line, Lordship. Last two paragraphs, Lordship.
Yes, 12, 11 and 12.
Yes.
Yes.
Well, normally, when somebody, there's a closure of statements, madam. When the trial court closes that you do not proceed, then people come and file this 311. But in this case, peculiar circumstances that they have already crossed, and they want to put some clarificatory under questions. The test of 311 is, my lord, the test is, would it allow to come to a reasonable and justifiable ground for interfering? Well, that's all. If it serves the interest of justice, lordship may allow, but the test
There's
is
some questionnaires were there, in fact,
Yes.
you have submitted.
yes.
Yes.
In
It is there.
page,
Page 25. I'm not reading, Lordship, may kindly go through.
Both said yes.
so as many as
5 questions, Lordship.
7 questions are there.
Yeah, but the PW, in respect to CW1, question number 2. And others are in respect to PW10, Lordship.
We should remember whether changing this, posing these questions at this stage, madam, how materially it would affect the trial. That is the test.
Just relying on your judgment, otherwise I'm leaving it to your lordship. Judgment.
The judgment you're relying?
Yeah, I'm giving them this painter. It's my lord. 2021-14 SCC. Page 1,
Any para?
12 and 13.
12 and 13.
12 and 13. State versus Srinivasan. Same that theory 311 what analyze the principle that has been repeated, madam. That's what. The petitioner has to show to the court, he has to demonstrate that this is going to materially affect the childish questions.
Yes, please.
Yes, my lord. Same thing, my lord. So whether it will be, my lord, beneficial for the judge decision of the case and whether it will make some material difference. That is the case, my lord. And another thing is that, my lord, the petition says, my lord, that there is some bona fide mistakes in, but there are decisions also in that regard, my lord, that bona fide mistake of the my lord, council cannot be a ground for calling again this, my lord. But I have the decision, my lord, that I have. It is there. Cannot fill up the lacuna, my lord, by calling up the 3-1 or that is one of the another aspects, my lord. So here, my lord, it seems, my lord, after 3-1-3, after 3-1-3, my lord, whether it will be, my lord, in the interest of the client or not. Let's say the second of the, my lord, the stage of argument. That is good.
Madam, trial court has not discussed whether it is a bona fide mistake or malafide mistake, lordship, only on the ground that we want to delay the matter. But in fact, lordship, coming to this high court, some delay occurred, lordship, issuing notice and appearance of the private respondent, lordship. Otherwise, we are not in a lordship. Our intention is not to delay the matter, lordship. Only one chance may be given, lordship. And the Supreme Court says that even at the back end of the trial also, this permission can be granted, lordship. Not only to the accused, even to the state also.
Okay. Let me that query. See. Rest of the matters I don't know.
Item number 40, may I pay for a date, my
Item number?
40. Just fixed today, madam. Last time, was due to paucity of time, my lord, could not take up the matter. I think the petition is behind the bar, my lord, the sheet of 89 petition, my lord.
He is behind the bar since last 1 year, 8 months.
1 year, 8 months.
Oh, see, listing of it, there are motion matters, are lots of motion matters are there. That's why this kinds of problematic to list this matter, reach these matters. Can it be date fixed? 40 days. It was in order call. First week is not possible. All the is already over.
Maybe after.
At best, second week.
Within a 10, my lord, within 10th of December, this sentence. Nearby 10th of December, my lord.
10, 11, 12 के बाद सारे December.
Maybe
11.
10, maybe my lord 12.
12 can be okay then. We are fixing it on 12.
12, my lord.
Please.
I love you.
Lordship. Mention item number 20. I was waiting for just the 19 had passed, so thought like 20 will come. Anyway, regarding this matter, the urgency is that on 29th, the CC is been fixed for this particular matter. It is currently being pending in before the learned special judge, Paksa, POXO. So praying for fixing a date, if it is possible on 29, on day after tomorrow, since interim has not yet been granted, and this case has got merit.
where at least interim could have been granted if court could have not, honorable court would have gone through the LCR. LCR is already there. So although was looking forward to move the matter, but unfortunately due to the paucity of time. So for fixing it on 29th,
But your date is fixed on which
to
day?
29th.
No, no, no. Date is on
Day after
29th.
tomorrow. Day after tomorrow. That is
No, no, your matter is there in for CC when it is fixed.
on day after tomorrow, 29th. So
Or you want to fix it on day after tomorrow?
no, on if it is possible tomorrow, Lordship.
Tomorrow. It not, if it is also it not reach.
Day after tomorrow.
It's lots of matters, and day after tomorrow.
Yes, if it is possible in the first half, then probably
29 করে দিব 22
oblige.
Wait, please, Your Lordship. With respect to item number 41, Your Lordship, any day in the month of December, Your Lordship.
December.
December.
Nowadays to December is now quite problematic because only 18-19 days we are getting.
I understand.
19 and 20 we're not going to list anything. Anything in a sense, there are motion matters will be listed already by the High Court. And my personal problem is a bit different also. They are from the other states, so they have to leave. So we are not going to list the matter on 19-20. But the rest 16-17 almost completed, I think. In the month of first week of January will do. First week of January.
Yes, first week.
First week of January we can be. It is a what I is for
For delay condonation.
delay condonation. Acha, I is for only for delay condonation. Delay condonation matter is there only can it be on 16-17 or something like that. On 16 realistic.
I'm deep.
Lordship, regarding item 46, Lordship, here only implement petition is there, Lordship, Lordship take up, Lordship on,
Item number
Lordship 46, Lordship.
46.
Yes, Lordship. 46, Lordship. Only implement is informant.
District is not possible. Maybe on 4th or 7th. 7th is a holiday. 6th, 7th. 7th Saturday. 6 to lots, 5 and 6 are both yes. At best 4th ko you find 4-12 realistic. Rest can please be rest and matters. Similar prayer.
Similar prayer.
Definitely she will help you.
7. Same implement petition has been filed.
She will help you definitely. Okay, I'm trying to instruct her as many as possible. We are listing it properly. Okay.